Good morning, everyone, again. My name is Gene Bird, and I'm a co-chair of the Russia-Eurasia Committee of the Section of International Law of the American Bar Association. Just to give you a brief introduction to the American Bar Association and the Section of International Law, American Bar Association is the voluntary organization of the attorneys, not only attorneys licensed in the United States, but also attorneys practicing in all over the world. The membership is open to all practicing attorneys. There are different levels of membership. And of course, if you're an attorney, if you're interested in becoming a member of the ABA, that would be that is a great opportunity to share knowledge with your colleagues, to meet new colleagues. The Section of International Law includes about 24,000 attorneys who practice in the area of international law, who are interested in international law, not only attorneys, the students, law students, as well as judges, the prosecutors from different countries, from different area of legal practice. We've been invited, and it is my great honor to be here today with a panel of distinguished speakers. We'll be speaking today about disputes, about the disputes or resolution of disputes, and about different views on the resolution of disputes and ideas of various commercial and or close to commercial disputes between individuals and states. The speakers who are here today, they're very distinguished professionals. There are some judges, and we have the prosecutors here. So I'd like to introduce them now. On the left of me is Bart Legum. Bart is the partner with Salons, the law firm Salons, in Paris, France. Bart is the chair-elect of the Section of International Law and will be taking on his responsibilities in August of this year. Bart he's the head of his firm's investment treaty arbitration practice, and he has over 20 years experience in litigating complex cases and has argued before numerous international arbitration tribunals, the International Court of Justice, and the range of trial and appeals courts in the United States. From 2000 to 2004, Bart served as the chief of the NAFTA arbitration division in the office of the legal advisor of the United States Department of State. And I will try to condense the description, but of course, if I go on and on with all the achievements of Bart, it's going to take me probably about at least half an hour. The next is Loretta Lynch. Loretta Lynch is the United States Attorney for the Southern District, for the Eastern District of New York. And for those of you who might be not familiar with the American the government or the legal system, United States Attorney is the federal prosecutor. So Ms. Lynch is the federal prosecutor for the Eastern District of New York. And before Ms. Lynch was appointed by President Barack Obama on May 3rd, 2010, and she took the oath of office of the United States Attorney from Chief United States District Judge Raymond Dearie. In that capacity, she is responsible for overseeing all federal and civil investigations and cases in Brooklyn, Queens, Staten Island, as well as Nassau and Suffolk County on Long Island. Before her present appointment as the United States Attorney for the Eastern District, she was previously appointed, and she served in that position from 1999 to 2001 when she was appointed to that post by the President Clinton. And before becoming the federal prosecutor, she was a partner in the New York office of Hogan and Hartson. It's common in the United States where attorneys and judges, the prosecutors and judges, before taking their positions, they work in private practice, and that's certainly the case with Ms. Lynch. Sitting next to Ms. Lynch is Dmitry Evseev. Dmitry is my colleague. He is also a co-chair of the Russia-Eurasia Committee. Dmitry is a partner with Arnold and Porter in London, and I understand Dmitry is from St. Petersburg, right, originally? So he's quite the atmosphere here is quite familiar to him. He is a Harvard graduate, and his practice focuses on international arbitration and litigation. He represents private parties as well as individuals in international disputes, as disputes relating to the Energy Charter, as well as other disputes. And he presently practices, he's a licensed attorney in the United States, but he now practices from London. Next to Dmitry is Glenn Hendricks. Glenn is the managing partner of Arnold Gold and Gregory, the firm I also work for, and I work from Washington office, and Glenn works in Atlanta. Glenn has been a chair of the section of international law, and he's been active in international practice. Among his achievements is he presently serves as the ABA representative of the U.S. State Department's Advisory Committee on International Law, which brings together 20 leading international law professors, practitioners, and policymakers to provide advice to the State Department on significant international law issues, and as a chair of the ABA's Task Force on International Trade in Legal Services. In 2001, he was retained by the International Finance Corporation to provide training on mediation advocacy to lawyers in Pakistan. Glenn also represents corporate and individuals in various disputes in the United States as well as outside of the United States, and serves as an arbitrator in international tribunals. And next to Glenn is Carolyn Lamb. Carolyn is, she's the partner with White & Case in Washington, D.C. Carolyn is former president of the American Bar Association. And truly, if I start reading Carolyn's bio, it'll probably take more than half an hour. But just to tell you, her private practice concentrates on international disputes, dispute resolution through international arbitration, litigation, and international trade matters. She has substantial experience with ICSID and its additional facility, NAFTA, and other commercial arbitral fora, including AAA, ICDR, ICC, Vienna Center, Stockholm Chamber, Swiss Chamber, and litigations in the federal court. And Ms. Lamb was appointed by President Clinton to the U.S. panel, and later by the government of Uzbekistan to the Uzbek panel of arbitrators for ICSID arbitration. She is a member of the American Arbitration Association Executive Committee and Board, and has served as an arbitrator on AAA international rules disputes. Sorry. And next to Carolyn is, there are so many speakers, so it takes a time, but it's good because we're hoping we will have more people by the time I finish introductions. But next to Carolyn is Judge Susan Braden. And Judge Susan Braden is the federal judge with the Court of Federal Claims, and which is a rather unique court, and she will share her experience and share the American experience, the American practice in resolving claims against its own state, how we in the United States and how foreign parties can bring claims against the United States and America in the special court, where there is only one defendant, the United States of America. Judge Braden was appointed to the court on July 14, 2003 by President Bush, George W. Bush. And she was confirmed by the unanimous consent of the United States Senate, and she was sworn into office by Senator Jeff Sessions, then chairman of the Senate Subcommittee on Administrative Oversight in the Courts. Her investiture was conducted on October 24, 2003 by Justice Sandra Day O'Connor and Justice Ruth Bader Ginsburg. In July 2009, Judge Braden was appointed as a member of the Standing Committee on Ethics and Professional Responsibility and Judges Advisory Committee to the American Bar Association. We have also not just, we try to set up our panel to have international representation, and certainly Bart, as I mentioned, is from Paris. We also have Sam Wordsworth. Sam Wordsworth is a Queen's Counsel from London, and Sam represented sovereigns. His practice focuses on public international law. He represents sovereigns in the international courts, in international tribunals, and he will share with us his knowledge and experience, as well as his views and thoughts on the future developments, and I'm hoping he will, of the sovereign immunity and the issues that can arise between individuals and states. And last, but certainly not least, and frankly, it was a surprise for me. I was just informed essentially 5 minutes before this session that we have a new speaker, and her name is Katerina Kudelich. Ms. Kudelich is a deputy head of International Law and Cooperation Department of the Supreme Commercial Court of the Russian Federation, Высший арбитражный суд Российской Федерации. I had a brief discussion with her, and she shared with me her ideas, and she would like to share with you the ideas to bring some ideas from the Russian side on the sovereign immunity, both in the context of litigation in the United States, as well as enforcement of arbitration awards against sovereigns against Russian Federation, as well as some thoughts on why Russia does not join ICSID. With that, I think I introduced everyone here. Thank you. And I would like to ask Glenn to maybe give some general background of the sovereign immunity, where it stands, perhaps some historical ideas where it stands now in the United States, and what is the applicable law, U.S. law in that regard. Glenn?
Well, thank you, Gene. So I'll kick off the discussion this morning with an overview of U.S. law on foreign sovereign immunity. And we refer to it in the United States as sovereign immunity. In some countries, it would be referred to as state immunity. It's a subject that has evolved very greatly in the United States over the past, certainly over the past 50 or so years, but even before that. Originally in the U.S., we followed a doctrine that allowed for absolute immunity of sovereigns. It dates back to a Supreme Court decision in 1812, which basically holds that every sovereign is sovereign in their own territory, and that based on the comity of nations, no sovereign will hold another sovereign liable. And this continued to be U.S. doctrine all the way until 1952, And the reason that 1952 is significant is that at that point, the U.S. State Department, the legal advisor, a fellow by the name of Tate, issued a letter which has been known as the Tate Letter, which adopted a much more restrictive view of sovereign immunity and is called precisely that, the restrictive theory of sovereign immunity. And basically, that continued for 24 years, from 1952 to 1976. The U.S. operated under this restrictive view of sovereign immunity, which had several corollaries to it. Still viewed, in effect, sovereign immunity as a matter of comity between nations, viewed it as primarily a political question rather than as a legal question. And therefore, the executive branch of the United States government, and specifically the State Department, played a significant and really the primary role in determining whether and to what extent and in which instances sovereign immunity would be extended to foreign sovereigns. There'd be litigation in which a foreign sovereign was sued. The U.S. State Department would issue a letter indicating whether they believed that sovereign immunity was appropriate or not, basically looking at it from the standpoint of, was the sovereign acting in a public capacity or a private capacity, and if in a private capacity, would indicate this in a letter to the court, and the court would proceed accordingly. There were a lot of problems with this. In effect, as you can imagine, because it was a political question, there would be opportunities for foreign sovereigns to weigh in. Is it too loud?
No, just it's on.
Okay.
Just a bit closer.
Okay. And so there was inconsistent application. There was also problems that in some instances of course, foreign sovereigns would be very active. In other cases, they would not be active at all in weighing in with the State Department. As a result, no letter would be issued, leaving the court in a situation to have to resolve the immunity question with no precedent other than looking at other State Department letters. It was a very unsatisfactory state of affairs. And so in 1976, Congress enacted what is known as the Foreign Sovereign Immunities Act, which continues to be in effect today, with a few amendments primarily in 1988. But effectively, it's been the same law in effect since 1976. And here, the Congress codified this view of restrictive immunity, again, distinguishing in a very general sense between public and private acts, and we'll get into that in a little more detail here in a moment, and transferred the responsibility for deciding immunity questions from the executive branch to the judicial branch. So it's a judicial determination at this point. The Foreign Sovereign Immunities Act, it serves a number of purposes. It starts with a sort of blanket presumption or rule that foreign states, and this is the term it's a very important term in the statute, that foreign states are immune in U.S. courts, and then proceeds to create a number of exceptions from this rule. And the exceptions, as is so often the case, are in many respects more important than the basic rule itself. So the statute also serves, it's a jurisdictional statute. And if you're familiar with U.S. law, we have personal jurisdiction and subject matter jurisdiction. Personal jurisdiction meaning, is this party subject to the power of the courts? It's something that is very controversial in many foreign countries, non-U.S. countries, and how U.S. courts apply this doctrine with doing business, et cetera. Well, the Foreign Sovereign Immunities Act removes all those issues with respect to foreign states. None of the issues, the long-arm statutes and things that you hear about in U.S. law apply with respect to foreign states. Instead, you look solely to the Foreign Sovereign Immunities Act, which, as we'll discuss in a moment, has various requirements establishing a certain nexus with the United States, depending on the exception that's being applied. It also establishes that foreign states, and we'll get to the definition of what is a foreign state here in a moment, may only be sued under the Foreign Sovereign Immunities Act. So there's no other basis or that can be used to bring a foreign state into U.S. court. There are several important implications to a party being determined to be a foreign state. Again, it means that the Foreign Sovereign Immunities Act will apply. It will mean that, with very rare exceptions, no punitive damages will be available. The exceptions are if the foreign state as defined is in effect an instrumentality of that state, such as a state-owned corporation. And then there's a very narrow definition for certain terror-related activities. The case will, the federal courts will have jurisdiction. The defendant, if the foreign state is sued in state court, as you know, in the United States, we have a parallel system of state and federal courts. If the case is brought in state court, the foreign state may remove the case unconditionally to federal court. The case will be heard without a jury. As many of you know, in the U.S. legal system, in both criminal and civil cases, there's a right to a jury. But if a foreign state is a defendant, the case is heard before a judge rather than a jury. Oh, here we go. So the question then is, well, what is a foreign state? It's very obvious in many instances. Obviously, the Russian Federation is a foreign state. It's very easy on one end of the spectrum to determine what that is. Political subdivisions of foreign states are considered foreign states as well under the definition of the Act. So an oblast, for example, of the Russian Federation would be considered a foreign state. Likewise, instrumentalities or agencies of a foreign state are considered a foreign state. The Ministry of Justice of the Russian Federation would be considered a foreign state for purposes of the Foreign Sovereign Immunities Act. But it also applies to, and you'll see the definition up on the screen, a separate legal person, corporate or otherwise, which is an organ of a foreign state or political subdivision, or a majority of whose shares or other ownership interests is owned by a foreign state. And this is where you get into, for example, state-owned corporations, which also fall within the Foreign Sovereign Immunities Act. With respect to state-owned corporations, there was a split in U.S. authority regarding whether an indirectly owned state-owned corporation was a foreign state within the meaning of the Act or an instrumentality of a foreign state. That issue was resolved in 2000 by the U.S. Supreme Court, which held that only the immediate subsidiary of a foreign state is considered an instrumentality for purposes of the Act. So, for example, if the Russian Federation owned in its entirety a particular state corporation, that corporation in turn had a subsidiary which was wholly owned by the first subsidiary. Only the first subsidiary in the tier that was directly owned by the Russian Federation would be considered a foreign state for purposes of this Act. The next tier down would not. Timing of the determination can be very important. The determination of whether a particular entity is a foreign state under the Act is made at the time the lawsuit is filed, which can have very significant practical implications. There was a case very recently in the United States involving the Anglo-Irish Bank, which was initially a private bank, had significant problems in the most recent recession. Lawsuit, as a result, was nationalized by the Irish government. Lawsuit was brought by creditors of the AIB, the Irish Anglo-American Bank, and to recover some $200 million. By this time, though, the bank had been nationalized, and as a result, even though with the time the parties were dealing with this bank, it was a private entity, because by the time the lawsuit was filed, it had been nationalized, it was now directly owned by the Irish government. It was subject to the act, and various immunities came into effect. The practical effect of this was that the suit could not be brought in the United States, and it actually invalidated a clause in the parties' agreement providing for jurisdiction in New York courts. So again, the starting premise of the Foreign Sovereign Immunities Act is that a foreign state, which is defined, fairly broadly, as I've said, including directly owned state-owned corporations, is immune. But there are a number of exceptions, and I'm not going to go through each and every exception. I'm just going to address a few of the more important ones. And at the very end, I'll summarize just very briefly, just the rest of them. The most fundamental exception is the waiver exception. As you can imagine, a foreign sovereign can waive immunity. This can be done either expressly or by implication. The most clear way of doing this, obviously, would be in a contract between the sovereign and a private party, in which there is a waiver provision. Courts have held, and I quote from one decision on the slide, that the waiver must give a clear, complete, unambiguous, and unmistakable manifestation of the sovereign's intent to waive its immunity. With respect to waiver by implication, the legislative history of the Act provided 3 examples of waiver. One of them is in the situation where there is an agreement to arbitrate, in which case, of course, the case would be referred to arbitration, but U.S. courts would have the authority to provide the appropriate relief, whether confirmation of the award or otherwise. More controversially, if the foreign state entered into a contract which agreed to apply U.S. law, just generally a choice of law provision, that has been deemed to be an implied waiver. Or if the foreign state appears in a U.S. court proceeding as a defendant and in a responsive pleading does not raise the immunity defense, that's deemed to be a waiver. Now, this particular exception has been viewed very narrowly. For example, we're trying to avoid getting into some of the intricacies of U.S. court practice, but if the defendant appears only to contest jurisdiction or to object that it was not properly served with notice of the lawsuit, or if it appears in order to make the argument that the case should have, for example, been referred to arbitration, if it makes a counterclaim but does not directly address the lawsuit, these are not deemed to be responsive pleadings. Courts will go out of their way to avoid an implied waiver in this situation. But if the foreign state does actually appear, files an answer on the merits, and does not raise the defense, then it's deemed to be waived. The second very important exception is the commercial activities exception to the Foreign Sovereign Immunities Act. And there are 3 subparts to this exception. And this goes back to the very concept of a sovereign acting either in its public capacity or in its private capacity. And you'll see the 3 subparts up here on the screen. The first one, if the action is based, and this term based upon is one that's very important in terms of the meaning of the statute, but if the lawsuit is based upon a commercial activity carried on in the U.S. by the foreign state, sovereign immunity will be, there's an exception to immunity in that instance. If the lawsuit, number two, if the lawsuit is based upon an act performed in the United States in connection with a commercial activity of the foreign state outside the United States. Or third, if the lawsuit is based upon an act outside the U.S. by the foreign state in connection with a commercial activity of the foreign state, and that act causes a direct effect in the U.S. And I'll come back to these three sort of subparts in a moment, but a more fundamental threshold question is, well, what is a commercial activity? How is that defined in the statute? And the answer is not very well. It's a very vague and somewhat circular definition. You'll see it quoted in its entirety up on the screen. Commercial activities are defined as either a regular course of commercial conduct or a particular commercial transaction or act. It goes on to say the commercial character of an activity shall be determined by reference to the nature of the course of conduct or particular transaction or act rather than by reference to its purpose. So in effect, you'll see that the statute, in defining what a commercial activity is, uses the term commercial twice without ever defining it. So it's very circular. The way that the courts have applied this is to look. Yeah. One of the leading cases in this area by the U.S. Supreme Court, the Weltover case, says this: when a foreign government acts not as the regulator of a market, but in the manner of a private player within it. So there's sort of very general sense that if the court is acting as a regulator, if the state is acting as a regulator, that's one thing, but if it's acting as a private actor would, that it's not. The second sentence of that definition is very important, that in looking at the activities, the purpose of the act is essentially irrelevant. It's the nature of the act. So, for example, if a foreign state is purchasing military equipment, the purpose to supply the military is obviously a very public purpose. Its state should have a monopoly on the use of force, and this is the ultimate sovereign power. But the nature of the act is one of commercial activity, of purchasing goods. So the fact that the goods are ultimately used for a public purpose is irrelevant. The court will look at the nature of the act, and that is a very they're acting as merchants in effect in a mercantile transaction of acquiring something. So the three subparts, each of them there is a requirement of a nexus to the United States because, again, the traditional personal jurisdiction analysis does not come into play with respect to a foreign state. It's purely governed by the Foreign Sovereign Immunities Act. So under the first clause, for example, there's a requirement that the commercial activity have, quote, substantial contact, that there be substantial contact with the United States, very fact-intensive inquiry. The second subpart of the commercial activities exception, very similar, that the acts or omissions have some connection to the U.S. And then the third is the one that probably generates the most litigation, and it's where the act, even though it occurs outside the United States, has a direct effect in the U.S. And here, obviously, if there was an agreement with a U.S. party and there was a breach, that would be considered to have a direct effect on the U.S. But the mere fact that there may be just purely an injury to a U.S. party in and of itself without some legally significant act occurring in the United States would not be sufficient to trigger the statute. And so the final exception that I'm going to cover, because I think it will touch upon an issue that will probably be hotly discussed later today, is the expropriation exception. And this applies where a foreign state takes property in violation of international law. That's the first requirement that the foreign state has taken property in violation of international law. And this international law component is extremely important, as I'll discuss in a moment. And then you get to the second part of the exception, that property is either present in the U.S. or the property is owned or operated by an agency or instrumentality of the foreign state, and that agency or instrumentality is engaged in commercial activity in the U.S. Start with, was the property taken in violation of international law? If the answer to that is yes, then is that property now in the United States, or is that property owned and operated by an agency or instrumentality of the foreign state, and that particular agency or instrumentality is actually engaged in commercial activity in the U.S.? This has become, it was actually a very seldom used exception. It has come up a lot in more the past decade in connection with arts and antiquities cases. It's the subject of a very lively dispute at the present time between the United States and the Russian Federation. This was referred to yesterday by Chief Justice Ivanov in his presentation in the morning, the Chabad case, which we'll discuss, I think, a little bit later. So just a few elements about the expropriation exception, because I think it'll be useful when we turn to the Chabad case in a little bit. First of all, this element that the taking or the expropriation be in violation of international law. If a state expropriates the property of its own citizens, that's deemed to be a sovereign act, that it's none of the United States business and would not be considered a taking or expropriation under international law. If, on the other hand, the foreign sovereign expropriates the property of a foreign citizen, that is considered to be an issue of international law. And this is often a question that is hotly litigated, was this an international taking or was it a domestic taking? And so, for example, in one recent case decided in the Ninth Circuit 2 years ago involving the expropriation of property in Nazi Germany of Jews, the question turned on the fact that the Jews had been deprived of German citizenship, and so the court held that it was not a taking from a domestic citizen. In this Chabad case, as we'll hear later, that was also a very significant issue, was the property in question, certain books, a library, was that owned by particular movement, which was not a religious body, that was not a citizen, in effect, of the Soviet Union, or was it the property of a citizen of the Soviet Union? The question is decided at the beginning on a preliminary basis. The plaintiff has to show that there's a non-frivolous basis for moving forward. There's no exhaustion of domestic remedies requirement. At least that's what most courts have held. There's some question about this still, but most courts have held that there's no requirement that, say, for example, if there's a taking in the Russian Federation, that the remedies here be exhausted. A number of other exceptions, which I will not get into in detail. Basically, if the case involves gifts or real estate in the United States, there's an exception to the Foreign Sovereign Immunities Act there. Tortious conduct causing injury within the U.S., although there's an exception to this exception that if it's based on a discretionary act by the foreign state, then this exception does not apply. Certain terrorist activity conducted by state sponsors of terror as determined in a very small list of about a half a dozen states, Iran, North Korea, etc. Enforcement of maritime liens, enforcement of arbitral awards, and then a situation where a counterclaim is filed again, where the foreign sovereign comes into U.S. court and the domestic party files a counterclaim. And so those are the remainder of the exceptions. I have talked only about exceptions with respect to jurisdictional immunity. There are also a whole other set of rules regarding immunity from execution on assets. And if we have time, we'll come back to that. But I think I'm just going to leave it at this for now. And I think probably teed up enough of the basics that we can kickstart the rest of the discussion.
Thank you, Glenn. Thank you for your presentation. I'm sure there are a lot of questions, and what I would suggest is that perhaps there are some other speakers, and maybe we can hear some other aspects of the sovereign immunity, of the state immunity in the United States and internationally, and then we may engage in the discussion, which bring different speakers and as well as, of course, members of our respected audience. The next speaker is Sam Wordsworth. I already briefly introduced him. Sam is the well-known international public law and practitioner. He represented a number of sovereigns, a number of states in international tribunals. His most recent public international law cases include Pakistan versus India, Georgia versus Russia, where he represented Russian Federation. He also acted for the United Kingdom in the case accordance with international law of the unilateral declaration of independence of Kosovo, as well as acted for Guinea in the case Guinea versus Congo. Sam will give us some light on the most recent decisions from the International Court of Justice, or decision from the International Court of Justice concerning the sovereign immunity, as well as gives us some European view from the, I guess, European, I don't know, continental or perhaps continental or British look at the sovereign immunity. Sam, please go ahead.
Thanks very much indeed. I'm not sure that the words continental and British fit together so neatly for somebody who practiced law in England or the United Kingdom. But thanks very much indeed, Jean. And I want to try and give a short non-US perspective today. And in doing so, I want to draw your attention to two recent cases, one the International Court case in the case between Germany and Italy, and the other a recent UK Supreme Court decision, NML and Argentina. And then finally, I just want to draw your attention to an important case to watch out for in the near future. To start off with Germany and Italy, many of you, well, I hope, have seen the recent judgment of February of this year, and you'll have seen that the case concerns the acts of German troops in Greece and Italy during the Second World War, including in particular the massacre of Greek civilians at Distomo in Greece, and also the treatment of prisoners of war from Italy. And what these undoubted unlawful acts of Germany have led to over time is a series of cases in the Greece and Italian jurisdictions, to which, of course, Germany's instant answer is, no, we are immune, we are a state, and you have no right to proceed against us. And that kicks off in two different ways so far as concerns the Germany-Italy case. First of all, it kicks off with respect to an Italian judgment against Germany. And this is the judgment that is the Farini judgment concerning the treatment of Italian prisoners of war. But the Germany-Italy case also brings to the court the separate issue of enforcement in Italy of a Greek judgment. And the Greek judgment concerns the Distomo massacre, to which I've just referred. So what we're looking at is immunity taking place at two levels, which of course is very important because we're very used to having to deal with immunity issues at two different levels. The level of adjudication and the level of enforcement. Because obviously it's no help at all for the claimant to have a nice judgment or an arbitral award against a state, but then not to be able to enforce it against its assets. I should also mention, just in passing, that Greece intervened into the case. Rather curiously, the only thing it intervened to say was that the case was very important for Greece and would be particularly important for Greece courts. And you slightly wonder why they bothered paying the airfare to make that particular point. It may be that if Greece and German relations had been a little bit better at the time, that Greece might have taken a slightly bolder stance. Now, the underlying facts obviously seem very far away from business disputes, and they don't strike one as being immediately relevant to today's discussion. But of course they are, and one of the reasons that they are is that the International Court is establishing or developing or noting what relevant rules on state immunity are as a matter of international law. This is a great rarity so far as concerns international tribunals. This is essentially the first time that the International Court has looked in detail at issues of sovereign immunity, as opposed, for example, to issues of immunity of ministers, foreign ministers, and potentially heads of state in the Congo-Belgium case. And one of the very important findings that the court has come to in paragraphs 56 and 57 of the judgment, by reference to its overview of state practice, is to recognise a right to state immunity as a matter of international law, which is very important indeed, and may in fact raise a question so far as concerns the overview of US law that Glenn has just taken us through, because, as we've seen, US law contains a number of exceptions to immunity. Some of those are very standard exceptions, but some of those are not standard exceptions at all. For example, Glenn touched on the immunity in relation to the terrorist exception. So that may bring into play a very interesting dynamic between a state's right to immunity as a matter of international law and what may happen as a matter of US law, where effectively, as a matter of US domestic law, any such right is removed. This brings me to my second point, or the second point of importance in the court's judgment, which is to say that the gravity of the alleged unlawful acts makes no difference with respect to the assertion of immunity. Again, you think that's important in relation to the terrorist exception that Glenn has just touched on, because there you see an example of where the underlying substance of the case does impact on the issue of whether or not there should be immunity. The court rejects that view, and of course it's fundamental to its decision, because it is looking at the most appalling acts, and indeed admitted acts, carried out by Nazi Germany during the Second World War. There is no question that so far as concerns affronts on human rights or internationally unlawful acts that amount to breaches of norms of jus cogens, the court had that material before it. Nonetheless, it takes the firm view that immunity is a matter of procedure. And because immunity is a matter of procedure, the court does not go into the substance at all, and it must afford that procedural right to the state in question. The third point I want to touch on in the court's judgment is the issue that has arisen in the domestic courts quite frequently, and it arises in the NML Argentina decision that I'll come back to in a moment, concerning the enforcement of judgments against a state. So in this case, the question was the enforcement in Italy of the judgment in favour of Greek claimants that had been given by the Greek courts. Now, interestingly, that the court here is really, I think, it's developing an international law position. I think before the court's judgment it would have been quite difficult to say how international law might approach such a question. But here it refers to various domestic precedents, the NML case, as I've said, also the Kuwait Airways and Iraq case in the Supreme Court of Canada. And it comes to the view that what the Court of Enforcement has to do is to ask itself whether, in the event that if it had itself had been seized of the merits of a dispute identical to that which was the subject of the foreign judgment, it would have been obliged under international law to accord immunity to the respondent state. So this lets in for the enforcement courts all the potential exceptions that you'd expect to have seen in the initial adjudicating state. So, for example, if there had been a commercial exception applicable in the adjudicatory state, then, of course, you would expect the judgment to be enforced. If, by contrast, the case concerns unquestionable acts carried out by a state in its sovereign capacity, like acts of war, even if those acts of war are completely unlawful, then one would expect immunity to be accorded. Remember, there is a right to immunity as a matter of international law, and therefore, when it comes to the enforcing court, again, that immunity should be accorded. Finally, I want to just touch on the way that the court refers on various occasions to the 2004 UN Convention on Jurisdictional and Immunities. This is a very important convention, the result of many years' work, and although so far it only has 13 parties, it has a reasonably large number of signatories, including, of course, the Russian Federation, also the United Kingdom. The Court of Justice, the International Court of Justice, doesn't say anything direct in terms of the status of the 2004 Convention. Of course, it's not yet in force. It doesn't refer to certain principles as being representing customary international law or not. But what it does is to use the 2004 Jurisdictional Convention as an important reference point. And I think this is something we can expect to be influential more broadly in terms at least of those states that are signatory states to the Convention, if not more broadly than that, i.e. that we can expect the 2004 Convention to become more and more influential. We've already seen that in the English courts, for example, right away. As soon as the Convention was signed off in 2004, the following year, for example, in AIG in Kazakhstan, ample reference was made to the Convention, and then in the landmark case of Jones in Saudi Arabia, the following year, reference was made to the Convention. Just so that I can give you a very brief overview of the 2004 Convention, people may want to come back to the details afterwards. It will be very familiar to the US audience because it contains a basic rule on immunity. It obviously provides that express consent of the state negates immunity. And then in Part 3 of the Convention, it contains a series of exceptions, proceedings in which immunity cannot be invoked. And there, of course, we see a commercial exception, which is in Article 10, various other frequently seen exceptions. Article 11 deals with contracts of employment. Article 12 deals with personal injury. Article 17 deals with arbitration agreements. Part 4 is also extremely important because that deals with immunities so far as concerns enforcement. Article 19 is of particular importance, dealing with post-judgment measures of constraint. And here you have, in particular, 2 exceptions which are worth very quick mention. One, of course, is consent. So, for example, if the state has consented in a written contract to execution, then that applies. And a separate exception in Article 19C, which deals with property that's in commercial use. And there's a fairly elaborate definition there. It has to be established that the property is specifically in use or intended for use by the state for other than governmental, non-commercial purposes, and is in the territory of the state of the forum, provided that post-judgment measures of constraint may only be taken against property that has a connection with the entity against which the proceeding was directed. So some very important elements there. You have to establish essentially the commercial nature of the property holding. You have to establish a territorial nexus, but you also have to establish this connection with the entity with which the proceeding was directed. And for those of you who don't know the 2004 Convention well, be aware that there is a series of understandings which are printed as an annex to the connection, very important in terms of the interpretation of various provisions of the Convention, including in particular Article 19. And one of the important elements of the understanding on Article 19 is that it doesn't impede on the case where you might be arguing for a piercing of the corporate veil, which, as I understand it, is an important exception as a matter of US law. In certain cases, you can pierce the corporate veil in terms of your enforcement exercise against state or state entities. I want to move on now to the case of NML and Argentina, this recent UK Supreme Court decision. And I'll give you a very little background in terms of the English law and state immunity, which is set out in the 1978 State Immunity Act, which has its origins in the 1972 European Convention on State Immunity. The European Convention at the time was thought to be going to be very significant indeed. In fact, it's not quite a dead letter, but it has only 6 states parties. Both the English Act and the 1972 Convention contain rules on and exceptions to immunity that are broadly analogous to the rules and exceptions that Glenn has just taken you to with respect to the FSIA. But, of course, there are none of the peculiarities that one sees as a part of American law. For example, certain specific exceptions in relation to expropriation or the terrorist exception. There is, of course, a commercial exception. In Article 7 of the European Convention, the commercial exception is broadly analogous to the US commercial exception. So you see the need there for a territorial nexus. By contrast, the English commercial exception, which is contained at Section 3(1)(a) of the 1970 Act, provides simply that a state is not immune as respects proceedings relating to a commercial transaction entered into by the state. So it's very broad indeed. No need for any territorial nexus, and it's then supported by a very broad definition of what is meant by a commercial transaction. Again, not, I think, a more expansive definition than one sees in the FSIA. It includes any transaction or activity into which a state enters or in which it engages otherwise than in the exercise of sovereign authority. And the concept of sovereign authority then appears again at section 14.2 of the 1978 Act, which deals with immunity of state entities, of course a very important practical day-to-day issue for anyone practicing in the field. And state entities are immune if and only if the proceedings relate to anything done by the state entity in the exercise of sovereign authority. If no exercise of sovereign authority, then the state entity is not immune. And that test that derives from Article 27 of the European Convention. If I can give you a practical example of how this works in practice, there's been litigation for more than 20 years in the English courts that arises out of Iraq's seizure of Kuwaiti's commercial airliner fleet during the first Gulf War. And this shows how wonderfully slowly justice can work, even in courts, even in jurisdictions that pride themselves on having a speedy and efficient system. There, in the key decision on immunity, which is a 1995 House of Lords decision, the House of Lords distinguished between the seizure of the aircraft, that was Iraqi pilots coming into Iraq, seizing the aircraft and taking them back to, coming into Kuwait and taking them back to Iraq. That was an act, Iuri Imperii, so a sovereign act, but the subsequent transfer of the aircraft to Iraqi Airways and their commercial operation, that was a non-sovereign act, and so the Iraqi Airways company was not immune so far as concerns the wrongful interference with Kuwait's property. Note, no link of any kind into the UK jurisdiction, so this is a long way away from the US analogue. The question I want to touch on very briefly with the NML case is how the commercial exception applies when it comes to the enforcement of a judgment against a foreign state. NML concerns a judgment that had been obtained in New York for $284 million by by a Cayman Islands vulture fund, which had bought a batch of discounted Argentinian state bonds. It had bought them for half price, then obtained a judgment for the full price. It then sought to enforce that judgment in the United Kingdom. And the question was, could it do so? And if it could do so, on what basis? The Court of Appeal held that it could do so because the underlying transaction was commercial in nature and therefore fell within the commercial exception of the English State Immunity Act. The House of Lords, by a 3-2 majority, or the Supreme Court, I should say, by 3-2 majority, overturned the Court of Appeal's decision, but in fact came back to essentially the same result, because instead of applying a test from the State Immunity Act, it applied a test from the 1982 Civil Jurisdiction and Judgments Act. And it interpreted that as permitting enforcement of a judgment against a third state, so long as the court making the judgment would have had jurisdiction in the matter if it had applied rules corresponding to those set out in the 1978 State Immunity Act. So it's slightly circular, but you get back to the same basic rule being applied, as we've seen was applied also recently in the International Court of Justice. You look at the underlying subject matter when it comes to enforcing the judgment. In that particular case, there was a waiver so Argentina could not be immune, but presumably one would have got to exactly the same result by reference to the commercial exception. I move on briefly to a case to watch out for, which is, as it were, the final chapter, or potentially the final chapter, in the Kuwait Airways litigation before the English courts, now in its 22nd year. And the story so far is, in very brief terms, that Kuwait Airways has judgments worth in excess of $1 billion, but curiously, Iraq only paid off judgments while Saddam Hussein was still in power. Since 2003, Iraqi Airways hasn't paid a single cent. So in light of this, with $1 billion outstanding, Kuwait Airways is now seeking to enforce judgments against Iraqi Airways directly against Iraq. There's a line of French and English cases which supports that approach so far as concerns enforcing judgments in the name of a foreign state against a state entity, such as, for example, a state-owned oil company, which actually has the money. And as I understand it, there's also a line of authorities in US law, the Banchek exception, which permits essentially the same thing. It allows the separation between foreign states and their instrumentalities to be disregarded where the state so dominates the instrumentality so as to create a principal-agent relationship, or where upholding the separation would work fraud or injustice. What Kuwait Airways is trying to achieve is different, certainly, from the pre-existing English and French line of cases, because it has the judgment against the state entity, but is trying to enforce against the state, which is a difficult argument, but one of great practical importance if it succeeds. Of course, in any given case, the underlying facts are going to be of huge significance. And some of the special facts in this case are that, as a matter of Iraqi law, Iraq would be responsible for the debts of a state-owned company, and there are also allegations of fraudulent conduct in terms of Iraq and Iraq Airways colluding to avoid the judgment debts. Very important to watch out what happens to the case in the course of time, because at the practical level, the claimant is always going to need assets against which it can enforce. And if, in an exceptional case, the range of assets can be extended from those of the state to the state entity, and even vice versa, this would be of considerable importance to all those who did business with states and state entities. Thank you very much, Dean.
Thank you very much, Sam. It was a very interesting view from outside of the United States, and gives you some alternative ideas, and I'm sure we will hear some other alternative views as well from the Russian side. But let me just take you a little bit different angle. There is much criticism that in some countries, the government of certain countries, they try to influence the court decision, and they're allegedly violating the principle of separation of power, allegedly acting as a power which influences the courts. And I have to admit that these countries, and maybe Russia or some other countries that this criticism is directed to, they're not unique. I have to admit that in the United States we have the same or similar situation, I would say, but we have a special procedure for it. And today, Ms. Lynch will tell us everything how the United States government brings its voice in cases where the United States government believes there are sovereign interests involved, and in cases where the United States government is not a party. Is it correct? Is it
Yes.
fair description of what
Yes,
you want
thank
to tell
you,
us?
Gene.
Thank you very much, Ms. Lynch.
Thank you, Gene. I also want to thank my two previous panelists for giving that excellent description of both the U.S. Foreign Sovereign Immunities Act as well as that excellent description of the role of sovereign immunity in the international courts. And I think we saw a number of similarities there. As was pointed out in the outline of the U.S. law on foreign sovereign immunities, and I certainly will not go over it again. However, until the passage of the relevant statute, the Foreign Sovereign Immunities Act itself, the issue of whether or not a foreign country that was brought into a U.S. court would in fact enjoy absolute immunity or even restrictive immunity was very much a political question, in that the courts always waited for the executive branch to express an opinion. The executive branch acts through its attorneys. As you have heard, I am the United States Attorney for one of the federal districts. So, for example, if the case were to be brought in my federal district, the State Department, acting on behalf of the executive, would reach out to the Department of Justice, who would then ask my office to file the appropriate document, which is called a statement of interest. And again, prior to the passage of the Act, these statements were generally filed in most cases where there was a friendly or positive relationship with the foreign government and where the foreign government had in fact made that request. The statute was designed to largely remove the executive branch from these decisions. As you can tell, just by the description alone, there would have to be certain diplomatic relationships between governments for a government to even make the request of the U.S. for this statement of interest. There would also have to be not just the request, but the acquiescence by the Department of State as well. And the perception was that rendering this issue, which should be more substantive and more consistent, one of politics, meant that it was also subject to the vagaries of the different political administrations that would be in power in the United States, depending upon the results of whatever the election was at the time. So in an attempt to gain consistency and to also codify the practice of recognizing sovereign immunity for most sovereign acts, but also recognizing the exceptions that in fact had sprung up involving commercial activity and the like, the statute was passed. That raises the question, of course, what is the role of the executive since 1976, since the passage of that statute? Does the executive branch still weigh in on cases involving foreign governments being sued in U.S. courts? And what deference do the courts give to an expression by the executive branch when they do weigh in? And the answer is there is still involvement. It is much more limited. In fact, there are very few cases on an annual basis. When does the executive get involved? When would the State Department request that a U.S. attorney file a statement of interest? Again, there is likely to be a request by the country involved, but also the State Department does not acquiesce to all these requests as it used to. The focus is supposed to be on a novel interpretation of law. Would the case expand foreign immunity in a way that is inconsistent with the statute? Are there issues involving the assets of the foreign government that are particularly important and things that should be preserved as well? So those instances when the executive branch gets involved, again, still at the request of the foreign country, not always acquiesced to, and no longer in every case involving a sovereign government in court in the U.S. In fact, it is rarely in those instances. The other instance I want to talk about just for a moment actually is separate and apart from our statute invoking foreign sovereign immunity, and it is probably the main area in which the executive branch would seek to express an opinion in district court. And that is when the acts of the sovereign state, again, the sovereign state that is being sued, involve what is called the act of state doctrine. This doctrine is separate and apart from sovereign immunity in that immunity is jurisdictional and decides the question of whether or not the court can even hear the case. The act of state doctrine is invoked when there in fact is jurisdiction, that is to say, the court may legally be able to review the case, but because the actions themselves concern so much the actions of a sovereign within its own territory involving its own citizens, they are considered inappropriate to be dealt with by the U.S. courts. This is actually an affirmative defense that a foreign government raises in federal court. Again, separate from the issue of jurisdiction, the court may find that there is jurisdiction because either of an exception or because an American citizen may be involved in a particular way. But if, in fact, the act of state doctrine applies, that is considered a defense and allows the foreign government to seek dismissal of the action. So I want to talk just a little bit about the certain types of cases where the Department of Justice does get involved. And by far, the most contentious and, in fact, the most difficult, similar to those that we've heard about in the international realm, involve primarily issues of appropriation of property slightly before, during, and after World War II. They usually involve a change in government. Obviously, the Nazi regime has been repudiated by all of the former countries involved, and as we know, many descendants and relatives of victims of that regime have sought redress and return of property in courts, both in the U.S. and in other countries as well, and in the international sphere. The other area in which the sovereign, at least in the U.S., the executive branch, tends to get involved is expressing a view as to whether or not there are crimes against the person for which an individual may enjoy diplomatic immunity. There have been cases in the U.S. where, and I'll talk about one in a moment, where individuals have claimed that they were working for someone who was a representative of a foreign government in the U.S., but that they were abused during that working relationship. And the issue arises as to whether or not that foreign official enjoys immunity because of their role as an agent of their state or foreign government. Now, as I mentioned, another question that arises is if the executive does not get involved in every case, which is the current state of the law in the U.S., one question that would arise is when the executive does get involved, that is to say, when a statement of interest or an amicus curiae brief is filed, does the view of the executive always prevail? As we've heard, prior to the enactment of the statute, once the executive branch expressed an opinion on the issue of immunity, the courts tended to accept it in every instance. They tended to go along with what the executive requested. What we have seen most recently, however, is that the views of the executive do not necessarily always prevail when they provide either an amicus curiae brief or even a statement of interest. Many times they do, but sometimes they do not. Now, I just want to touch on a few cases, because I want to leave time for questions. Also, I think the other question I want to raise as the overarching issue here is if, as I've noted, the state of the law has changed and the view of the executive is rarely sought and not always followed, then you would ask yourself, why invite that opinion if, in fact, the court does not intend to automatically follow it? There has been a lot of discussion on this issue in the case law, both at the trial level and the appellate level, going up to our own Supreme Court. And in fact, while it is not totally clear, what has emerged is the view that the view of the executive is entitled to deference, but it is not necessarily dispositive. In particular, if the executive expressed a view with regard to one of the exceptions, the terrorism exception, for example, they would be providing the court with certain information that it might not otherwise have. The court could then use that in making its decision. But in many instances, we see the court saying that while they appreciate the Department of Justice providing a statement of interest, either because they are finding immunity and no jurisdiction, they need not reach the issue of whether that statement of interest should affect them, or they will, in fact, take it into consideration, but expressly state that it is not the dispositive reason behind their holding. In fact, one of the most important cases within U.S. jurisprudence over the Foreign Sovereign Immunities Act was, it was about 8 or 9 years ago in 2004. Hope my math is correct. But the issue arose as to whether or not the Foreign Sovereign Immunities Act was retroactive. Did it apply to activity before 1976? This is an important issue because, as I've noted, some of the most gripping cases that come before the U.S. courts involve the allegation of the inappropriate taking of property in the 1930s and the 1940s. That was a time when, as we've heard, the sovereign enjoyed almost complete immunity. This would, of course, mean that even if an exception that we recognize today were to apply, that there could never be redress for individuals who had suffered these horrific losses. This case ultimately made its way to the Supreme Court. In fact, the name of the case was Republic of Austria versus Altman, and it was decided in 2004, and our Supreme Court held that, in fact, the Foreign Sovereign Immunities Act and its current definitions and exceptions would be retroactive to activity that occurred before the statute, as long as, of course, the case itself was brought after the statute was in force. In that case, interestingly enough, the Department of Justice did file an amicus curiae brief arguing against retroactivity, and it was one of the cases in which the courts declined to follow the executive's expression of what they thought that the law should be. I'm just going to give you a few other examples of when the issues of sovereign immunity have been placed before the executive branch and have led the Department of Justice to express a view. Another noteworthy case, and actually was a case in my own district in Brooklyn, New York, was Garb versus Poland. And this was a case involving a number of descendants of Jewish families who had suffered having their property taken during the war by Poland. And there, initially, the district court dismissed the case, finding that there was sovereign immunity by inferred or conferred upon the government of Poland, because in fact at that time it was finding that the statute, Foreign Sovereign Immunities, was not retroactive, and therefore there was absolute immunity. During the time that this case was being litigated, the Altman case that I just mentioned was decided by the Supreme Court. So the case ultimately was remanded back to the district court to consider whether or not, in fact, any of the exceptions to foreign sovereign immunity did apply. This case generated a great deal of emotion and a great deal of publicity, obviously because the plaintiffs had suffered greatly and their descendants were seeking the return of property that most people from the outside looking in would in fact say they certainly had a valid claim to. But the issue, of course, was whether or not the U.S. courts had jurisdiction over the Republic of Poland, not the substantive issue of whether or not the plaintiffs had actually been harmed. And in the opinions, we see the judges writing to acknowledge the suffering of the plaintiffs, but ultimately holding that because the taking had occurred within Poland, had involved Polish citizens, and had in fact been wholly contained within the state, and did not have any commercial nexus or connection to the United States, that in fact Poland did enjoy sovereign immunity there as well. Now, in that case, the Department of Justice, again speaking on behalf of the executive, did express a view indicating that the court should not expand the exceptions to sovereign immunity. But the court held that because of the first reading of the statute indicated that there was no jurisdiction at all, that the views of the executive need not be considered there. So again, although the views had been invited and the State Department had requested that they be made clear, the court felt that they did not need to reach the particular views of the Department of Justice in that case. What was interesting in my colleague's comment with respect to the litigation, I think, in the UK involving the Republic of Argentina, is that there is, in fact, a very similar case in the U.S., in the New York courts, involving a very similar cause of action. And that case was NML Capital versus the Republic of Argentina. And that case was a little bit different because the issue there did involve, in fact, a commercial exception because Argentina had defaulted on certain bonds that it had issued, and the bondholders brought an action in the New York courts seeking to collect their debt, and they ultimately prevailed. But as we all know, if you do civil litigation, one can prevail below. The issue is, how do you enforce a monetary judgment? And there, the issue of sovereign immunity is raised anew if there is a situation where there may be liability, there may be jurisdiction, but the separate question of, can the assets of the foreign government be used to satisfy that judgment? Are those assets themselves covered by sovereign immunity? A separate question from the underlying liability. And in that case, ultimately, the Department of Justice did submit an amicus curiae brief in support of Argentina. After the bondholders prevailed in the New York courts, they sought to enforce the judgment by attaching funds that were in the account of the Argentine National Bank that were being held at the Federal Reserve Bank of New York. As you know, the Federal Reserve Bank and its many branches act as the central bank of the United States. Most countries have accounts there, and most countries do, in fact, have national funds there. And the Department of Justice position in its brief was that the funds that were held in connection with central banking activities, core governmental functions of Argentina, were immune from attachment under the Foreign Sovereign Immunities Act. And in fact, the Second Circuit, our appellate court, agreed with that view and ultimately vacated the attachment of those particular assets. So you see, we have to look not just at the jurisdiction on the underlying substantive case, but also as to whether or not there would be jurisdiction to, in fact, provide compensation for a plaintiff were they to prevail. Another interesting case that was held, that actually was in my courthouse, in the Brooklyn courthouse, was Avalar versus Katoya Construction. And there, workers had been injured. They were working on a site that was being overseen by the Democratic Republic. Actually, it wasn't Democratic Republic at the time. It was the country of Congo. They were working on the mission on the building, and they were injured there. In fact, the issue was whether or not those plaintiffs could, in fact, recover damages for the personal injuries they suffered in the course of working on this construction site. In New York State Court, the plaintiffs actually prevailed. They prevailed only because there was, in fact, a default judgment. But the issue again, can those plaintiffs collect from the Republic of Congo? And if so, how can they collect from the Republic of Congo? There, the plaintiffs filed an action seeking to attach the mission's real property within New York and to collect judgment there. That would have led to the seizure of the property. In my country, if property is appropriately seized, it can be sold to satisfy a judgment and money given to the plaintiffs. There, the U.S. did submit a statement of interest, contending that the service of process on the mission and the enforcement of the judgment violated the Foreign Sovereign Immunities Act and international law. Again, the mission, as the active agent of the country within the U.S., is serving a purely governmental function. So while those plaintiffs' judgment still remains, they must find another way to seek compensation. Another interesting case that arose a few years ago, where again the department filed an amicus curiae brief, was a case where there was an issue again involving the Congolese government, and plaintiffs alleged that the oil company, the state-run oil company of the Republic of Congo, was involved in corruption, and they brought an action under the U.S. racketeering laws. These are the laws which we use to essentially find criminal and sometimes civil liability for organized crime and the like. There, again, the facts of the case were such that people looking at it felt that the behavior certainly had been wrong and the plaintiffs had been harmed. But the issue there was whether or not there was a commercial exception to the Foreign Sovereign Immunities Act there. And yes, the oil company is engaged in commerce. They are a state-owned oil company. They were involved in commercial activity, but none of that commercial activity involved the U.S. It did not touch upon either a U.S. citizen or U.S. property or U.S. interests. So despite the fact that this, again, was another plaintiff that had suffered harm, immunity was found for the Congolese government. And the last case I want to conclude with was, again, another recent case where it was Swarna versus Al-Awadi. It's about 2 years old. And again, the department filed an amicus brief because there, the former domestic servant to a former Kuwaiti diplomat brought an action against the diplomat and the diplomat's wife. And the allegation was that while this individual was working for the couple, that she was subjected to a variety of inhumane conditions, including sexual abuse, slavery, involuntary servitude, and forced labor. The issue there was whether or not this particular diplomat and his wife were acting on behalf of the state in employing this individual and in the way in which they treated her. The Department of Justice brief said that the former diplomat did not enjoy diplomatic immunity because the actions in question were not performed within his diplomatic functions, but within his personal capacity. This was an individual who had been hired to act as the personal servant of the diplomat and his wife. And even though she worked for them in property owned by the Republic of Kuwait, the court ultimately found that this was a personal employment contract between the parties and that the diplomat did not enjoy immunity there. Now, again, that does not resolve the issue of whether or not this plaintiff will be able to prevail in her action for the harms that were done to her, but it did render her able to pursue her case in court. So those are just a few of the examples. And as you can see, they range in subject matter, they range in result, but they illustrate the types of situations in which the executive branch and the Department of Justice seek to raise issues and concerns involving foreign sovereign immunity in the district courts. Is it raised in every case? No. In fact, in the majority of cases, as I mentioned, the executive does not express a position, but lets the court proceed there. How does it come up? As I mentioned before, the State Department will make the request of the Department of Justice. There are a few occasions in which an action may be pending in a court, and the court may have questions as to whether or not the actions fall under the statute or not. And the court may request that the Department of Justice issue a statement of interest. When that occurs, that request is transmitted to the State Department for that State Department to make the ultimate decision. So thank you very much for your time this morning.
Ms. Lynch, thank you very much. I just have a quick question. I would like to leave most of the questions from the audience to maybe after the next speaker regarding the issue of sovereign immunity. But in the procedure where the U.S. government, the executive, issues a statement of interest or submits and files statement of interest with the court, do the party have the opportunity to respond, to comment? Do they become aware? Do they get notified about the statement of interest?
They ultimately do receive notice that a statement of interest is going to be filed, and then they have the opportunity to comment on that. Sorry, I think I knocked off my. It becomes part of the pleadings of the case. There is, in fact, a statutory section under Foreign Sovereign Immunities Act that provides for this. Provides for the statement of interest.
Okay, thank you. Thank you very much.
But they don't. I think just to follow up on your question and to anticipate a question, do they have the opportunity to object in advance to the request and to weigh in on the department's decision to file such a statement, and they do not.
Okay, All right, that's interesting point. We're here today in beautiful city in St. Petersburg, and this is probably the cradle of the Russian sovereignty. This beautiful winter palace, these walls were built at the time when there was the sovereign immunity was probably pretty much close to absolute. There was no exceptions. There was no issues that the sovereign, the emperor, the tsar, or the queen or the kings would be subject to a lawsuit, would be named defendants in a lawsuit. That was here, of course, in Europe. But coming back to the United States, in our procedure, in our system, the idea that the government, the sovereign, can be sued, can be subject to a process under certain circumstances, under certain conditions, was part of the development of the American legal system. And one of the acts of the United States government in the 18th and then later in the 19th century established and developed more a special court, a court where there is only one defendant, and that defendant is the United States of America. And this is the court where every citizen of the United States, and not only citizen of the United States, but a foreign company, a foreign individual, they can come and sue the United States. And we're lucky today to have Judge Susan Braden, who is one of the judges of the Court of Federal Claim, where there is only one defendant. And but in words of President Lincoln, it is as much the duty of government to render prompt justice against itself in favor of citizens as it is to administer the same between private individuals. And this is one of the principles that the Court of Federal Claims and the American justice system is built upon. And I'd like to invite Judge Braden to.
Gene, before you start with the next speaker, I just wanted to offer my apologies to the group because I have to leave for another panel. So I want to apologize for not being able to remain for what's going to be a very interesting discussion.
Okay, if I may, would you have maybe 3-4 minutes to answer if there are any questions for Ms. Lynch? I apologize, Judge Braden, but if we may.
Actually, you were talking about the claim before New York court against Argentina. Is there a new class action in relation to threats before New York court submitted by Texas company? Can you please share your views, if any? Because of expropriation of Repsol made by Argentinian government last month.
If you could, I couldn't really hear you. If you could repeat it, please.
All right. So
Thank you.
Now it's better or not? It's good?
Yes.
All right. So you were talking about sovereign immunity and the class actions before Argentina, which were successful. And could you please share your views in relation to the last class action submitted before New York court, district court, by a Texas company in relation to Repsol and expropriation of Repsol made by Argentinian government?
Ah, okay.
As much as it is possible.
Right.
For the judge.
Right. I'm actually not familiar enough with the case to speak directly to that. I think the issue, again, would have to be whether or not the Texas company would be able to bring the suit, and then separate and apart from that, would they be able to collect a judgment? I would imagine, I would anticipate that based upon the decision in the Argentinian bondholders case, that the plaintiffs in that case would be looking at assets that are not so intertwined with government functions. But unfortunately, I'm not familiar enough with the case to really comment upon it.
All right, thank you. And maybe you have some statistics of successful enforcement of judgment before the assets of sovereigns in the United States.
You know, I would not have them at my
Thanks a lot.
fingertips, sorry.
Thank you.
I don't believe there are any more questions. Thank you very much, Ms. Lynch. And again, it was a great pleasure to have you on the panel.
Thank you all for having me.
And coming back to our program, we have Judge Braden from the Court of Federal Claims. Judge Braden, please.
Thank you very much. It's a pleasure to be here and to participate in the conference. I have to acknowledge Carolyn Lamb. Not only is a good friend of mine, but when I think of international law, I think of Carolyn. Let's just put it that way. They're synonymous in terms of my thinking and many of my colleagues. How many of you have heard the word lobbyist and know what it means? Just raise your hand. Okay. In the United States, a lobbyist is basically, the concept is someone who asks someone in government for a favor in exchange for remuneration. Our court, in fact, was begun because of lobbyists. There's a famous hotel in Washington called the Willard Hotel. It's like the Grand Europe Hotel here, or you can say if you were in New York City, maybe the Waldorf. And after the Civil War, the different generals, General Grant primarily, sat in the lobby of the hotel. And people would come and say, you owe me because the Union soldiers came through my farm and took all my cows and horses. And you said you'd come back and pay me later. And so here's my invoice. And so they would sit there and decide whether to pay or not. Another way that this happened was there were individual acts in Congress. Someone would go to Congress to get a special act saying, you owe me money because you burned all my crops, you ate everything in my food cellar during the war, and I need to be paid for that. And so Congress decided enough of this already, that we need to have a formal procedure for when the government has given up sovereign immunity and will pay for various acts. And over the years, the statute that we operate under, several of them, but primarily is called the Tucker Act, where you can come, the government has waived sovereign immunity and says we are not, we will not assert sovereign immunity, and you can proceed with your case. Let me give you a little bit of an example about the type of jurisdiction we have and the amount of monies involved, and I'm not going to be as long as the other speakers, so that'll give you time to ask questions at the end. Approximately 40% of our cases concern government contracts and bid protests. And let me give you a couple of examples which I think you'll find interesting. In the United States, all the nuclear power companies, when they got their licenses to do nuclear power, were required basically to enter into, by an act of Congress, to enter into an agreement where they would pay the United States a certain amount of money to pick up their spent nuclear waste. I call it garbage contracts. The garbage man was supposed to come every Friday to pick up the garbage, etc. Well, over time, the government has never come to pick up the garbage because they don't know where to take it. And you may have heard about Yucca Mountain, or where they're going to store it in the United States. They put it in a mountain, in your backyard, shoot it to space, but they don't seem to know what they're going to do with it. So what they've left the nuclear companies, is to store it on site. And the nuclear companies decided, well, wait a minute, we paid you to pick up the garbage, but now we have to take care of the garbage. And so the government is now liable through a long period of litigation for paying the utilities. And so they come to us, it's now been established there was a breach of contract and their damages, and they come before our court and they say, we built this facility, we had to hire these workers, this type of thing, and we are entitled to this amount of money. And so they come back to our court every 6 years, basically, with their shoebox of receipts. This is what we spent, and we go through and make awards. That's just one example of the type of cases we have had. We've had a large number of savings and loan cases that arose from the crisis we had a number of years ago, where Congress passed an act and said to the banks, if you will buy a healthy bank, strong bank, if you will buy this weak bank, we will make it better for you because we will recognize goodwill and some other things on their books. Well, that was changed, and when it did, a lot of the banks got into trouble. So they sued for breach of contract, saying that, wait a minute, when I bought this weak bank, you said I could put this amount on my books. And now you're saying I can't do that, and I've got to raise additional revenues, et cetera, to comply with other banking laws. And the Supreme Court of the United States, that case came before our court, went to the Supreme Court. The Supreme Court said that's a breach of contract. The United States induced people to come and purchase these banks. They reneged in the promise, and so therefore they had to pay. And these cases have really, just these two categories alone, have been billions of dollars. Not millions, billions of dollars. I was trying to sit here when I was thinking, I think alone, since I have been on the bench in 2004, in a variety of contexts, probably have issued between $4 and $5 billion of damages, which have been upheld. They're not in fighting, they've been paid by the federal government. They're not paid with interest, but they're paid. Bid protests are a very interesting part of our jurisdiction. When the government says, I want to buy something, they submit bids, and then a bid is selected. But under our system, someone has the right to say the government violated a certain number of rules when they issued that contract. It's called a bid protest. And let me give you a recent example of a case that involved me that would be of interest, I would think, to some of you. The Interior Department of the United States issued a contract for purchasing new cloud computing services. And many of you have heard about the cloud, storage, etc. This is very important because in the United States, these first contracts are going to determine, in all likelihood, who will control the cloud and the government, because each agency has to speak to the other agency. So it's got to be a seamless web. And there have only been 2 or 3 of these awarded. The one awarded originally from the Interior Department was to Microsoft. Google filed a bid protest. I enjoined the Interior Department from awarding to Microsoft because I felt that they had not sufficiently looked at Google's capabilities and had not followed certain procedures we have. It's called FAR regulations about how they made the determinations and in a number of other things that they did. So I enjoined them. And they let the contract again, came back, and it turns out that the government acquired cloud computing services from Google at 1/3 of the cost that they would have under Microsoft. So while the government didn't like me, now they like me because it wound up saving the government money by going through the process. About 10% of our cases are federal income tax returns. In our country, if you have to pay the tax, then you can go fight. Usually these are big amounts of money, and a lot of these cases are what are called shelter cases, where there are creative ways, basically, of interpreting the statutes in order to save tax paying. And those are very interesting cases. I'm going to go over a couple of them, and I'm going to come back to intellectual property, which is a growing area, and I think it's something that you should take away from the conference, because our court is going to be much more involved in that area in the future. About 10% of our cases are split between land and water rights cases. And let me give you 2 specific examples which might be of interest to you. Do you remember the Katrina hurricane? There was news around the world it had hit New Orleans, and New Orleans was basically a disaster area for quite some period of time. It turns out that the Corps of Engineers, which is the engineers that work for the federal government, some years ago built a navigational channel in order to enable the oil ships to go. New Orleans is like a bowl. So rather than having to go around, they could go through basically the swamp areas that surround New Orleans more efficiently. It was also a make-work project because lots of people were employed during the time they were digging the ditch. But no one really thought very much about the fact that what happened is that ditch brought in salt water. And the salt water wound up destroying all of the wetlands. For every mile of wetland you have, it will slow a hurricane down and reduce the size of it, which is one of the reasons the coastal portions of the United States have survived so long. But this navigational channel basically destroyed all of that and facilitated, not only that, but it created a tunnel where the wind came into New Orleans. So there has been a lawsuit brought. There were two of them brought, one in my court for a taking, saying that the act of this ditch that they built resulted in a condition which caused flooding on my land. I have tried the case. I haven't issued an opinion, but I have indicated from the bench that I felt that the plaintiffs had made a very good case. The same case was tried in New Orleans in a district court, before a district court judge, under a tort claim. And Carolyn used to be, before she became the international czarina, she was in the litigation branch of the government that does torts. And the government in her old branch defended that lawsuit. They were saying it was a tort rather than a taking of property, that it was a tortious act. The judge there, Duvall, said that it was, and that opinion has been affirmed by our Fifth Circuit. So the government, I think, may decide to take cert, but it's going to be very difficult, I would think, for them to find a cert-worthy issue in the case. What I've done is I'm waiting. I wanted to wait until the en-banc took place. In the circuit court, you can have an en-banc of the entire court. You have 3 judges, but you can have the whole court sit. They're going to sit on this, but it's very likely they will affirm the Fifth Circuit for a variety of reasons, and then I'll issue my opinion, probably sometime late fall or early next spring. Also, the Supreme Court of the United States has taken cert in a case concerning intermittent taking by water invasion, which may be relevant. So we're going to wait and see what they have to say. But that's not the type of case that might be of interest to you in that type of jurisdiction. I also had a case this year about a ranching family. They have run cattle for generations in the state of New Mexico. And under U.S. law, water and land rights law in the western United States came out of Spanish law. And under that law, if you use the water, you had a property right in the water. So since the cattle owner could say, we have been going to this place to get water forever, the cattle know where to go. I don't know if they send each other notes when they're born, but the cattle get up in the morning and they know exactly where to go. And in the interim, the United States built a national park around the land. Well, this made no difference to the cattle. They weren't impressed by the fact there was a park. The Park Service, however, gave the owner of the property the right to run so many cattle a year in the property. Congress some years ago passed something called the Endangered Species Act. And there is a thistle, a little weed, which lives in the swamp area of the park, and the thistle is eaten by an owl, which is also endangered. So they have denied the cattle owner the right to graze and to go in to drink the water. So the landowner said, well, that's fine, but that's my water. That's a taking of my property, and you owe me money. And I've tried that lawsuit, and I will be issuing a decision in that probably relatively soon. But it's very interesting because you can see the conflicting governmental policies. I mean, someone has property. They, for years, have run their cattle there. They've been prosperous. It's a very large entity. They haven't done anything wrong. The cattle don't pay much attention to the thistle. It's interesting because the state, the Forest Service puts fences around the water so the cattle can't in, but of course there are lots of elk and moose. And they don't know that they're not supposed to drink the water either, but they're allowed to be in the forest. So they knock the fences down, and then the cattle go in. So it's quite a drama, but it's a conflicting area. And the issue is, can they protect the species? Yes, but if it impacts someone else's rights, it may come at a cost to the government. They can make choices. So that's going to be an interesting case to watch and see. That because these are issues obviously that are of interest to our Supreme Court, where you have conflicting issues within the federal system. We also handle Indian trust cases. You could look at those in the context of indigenous persons that have rights there, where they have been moved to different places in the country, and the government has made promises to them, and whether they've kept those promises or not. We have a very special vaccine program also in our court. The vaccine manufacturers in the United States decided that they did not want to be subject to our tort law. They agreed, Congress passed an act, and they put all those cases in our court with special masters, and they come up to us to sit as a one-person court of appeal. A very interesting, very specialized system, which I can talk about if anybody has any interest about that. And we have a small group of our cases are military pay and civilian benefit pay. I just issued a decision this last month in a case where I found that the government was liable for changing the benefits that were given to Navy lawyers who entered the service during Vietnam, as they're called JAG officers, but it's the Corps of Engineers, and they changed. They did not conform with the pension rights that they were accorded by Congress. That'll be very controversial, and the government will, obviously will appeal that. But I think it's the statutory interpretation I've given is fairly clear, and that those gentlemen, there were no women at that time, but there'll be a large number of them that will be affected by that. So this is an overview of kind of what we do. All of our cases go to the Federal Circuit, which is our appellate court. They're upstairs in the same building, so we're pretty close with all of them. Several members of that court, including the current chief judge, were members of our court. So we have a close relationship. I've saved for last intellectual property rights. These are interesting cases where people say the government is now using technology, or they're using something where my patent was used. Could be copyright as well, but patent primarily. And let me give you two specific examples, and then I'll conclude my remarks. I have a case I've issued already concerning night vision goggles. The fight is really between Honeywell, who says it's my patent, but the manufacturer of the airplane equipment was Lockheed Martin, and the manufacturer of the panel inside of the airplane was a company called L3. So what Honeywell is saying is they sued the government. They said, government, you are flying airplanes that have my patent in it. Then the government brings in Honeywell and Lockheed Martin. But the fight essentially is between the private parties and the government. If there are damages, the government pays, but then they go to the other parties and say, usually they have an indemnification agreement, but then you owe me money. That's how that works. So that's been a very interesting case. And I also have a new case, which I haven't gotten involved with yet, but it's concerning the stealth bombers. And the party of interest there will be Boeing, that has made some of these vehicles. And that'll be a very interesting trial, very interesting new technology. And I also have one on microwire, which involves the CIA. And if I talk about it, I'll get shot. So that's what I do. And I enjoy what I do very much. Our courthouse is across the street from the White House. If you are in Washington, please see me. I work for you, or I work for the people of our government. I'm usually there. We have a nice cafeteria. I will take you to lunch. It's easy to find me. And you can see the White House from my office. I can see it, and I go over there and I look to see what Obama's doing all the time. I want to keep my eye out on what's happening over there. So thank you very much. But that's what we do. That's what I do. And I hope, I know you have a similar system in Russia. I don't know how much similar it is in terms of the robustness of the jurisdiction, but that's what we do for a living, and thank you very much.
Thank you very much, Judge.
I can also tap dance and do ballet.
Well, it's not that you don't get to ask questions too often from a federal judge. Usually, a federal judge asks questions. So I certainly don't want to miss this opportunity. And I just have a few questions right now, and maybe we'll have more questions from the audience as we move forward. But let me ask you, in the Court of Federal Claims, can a foreign individual, can a foreign company bring a claim against the United States government?
Sure. In fact, I had one. And I had one involved with an individual, actually, a corporation from Russia. And it was a very strange contract because it came about because the United States government was giving money to people who would agree to convert some of the facilities from the Cold War into civilian production. And I don't know what they made in this plant over here, but they were going to make die casters. And it turned out we actually had as a witness what it would be the equivalent to the Vice President of Russia. And he appeared on video conference during the trial, which was very nice of him. The long and the short of it, I ruled against the plaintiff. And I also thought that they were trying to explain the fact that they didn't really do their part of the contract and blame it on the Russian government. And I don't think they thought that the Russian government was going to participate, so they wouldn't have that evidence, but they did. And it was very nice. I mean, it was very nice. The State Department made all the arrangements. There was a video conference. The gentleman came out, answered the questions. I had a translator. Then we had another witness.
Great, great. What about you mentioned about the cases where the contracting party, where the private party provides services to the government. What about the reverse situation, or rather a situation where a government property gets privatized, gets sold?
Government property is what?
Get privatized.
Okay.
Where the government property is sold to the private parties. Are there cases like that?
Well, if the government has sold the property, then the government doesn't have an interest any longer.
But are there any possibility to bring a protest to the procedure, how the property was sold, any challenges, any objections, the privatization process?
Right. I think I'd be glad to talk to you about this, without involving, if you have a case in mind. But the government has to have an interest in order for me to have jurisdiction. If the government has sold property and no longer has an interest, I may or may not have jurisdiction. You would have to look at the facts of the situation. Okay?
Okay.
And we've got other speakers, so as a judge, I'm going to ask you to move along.
Okay. Thank you. Yes, absolutely. And yes, we certainly have.
I'm extending my jurisdiction here.
And
you're on the foreign soil.
How frequent are the cases when foreign private parties sue federal U.S.
How
government?
quick?
How frequent?
Not very.
Not very.
Not very. But that doesn't mean. I think Carolyn probably have more insight. I mean, I think the arbitration process is so much more robust now. And if you go into court, you get discovery. And not everybody wants to have someone look up their skirt. So there's some good reasons why people don't want to go into litigation. And that's fine. There's lots of ways of solving problems.
Okay, well, thank you very much. Now I will move on. Now next speaker is Ekaterina Kudelich, and I have to admit that oh, I'm sorry. I didn't.
Microphone?
I think the interpreters.
Interpreter can't hear you, apparently.
Predominantly English understanding of this. That is why I try to speak English, not Russian.
Mic, use the mic, sir. Мимо микрофона.
Yes.
No. Yes.
No, yes.
You're good.
So, my name is Roman Kolotkin. I have a kind of comment and a kind of request, probably, to the members of the panel who are going to speak and to those who have already spoken in this very interesting discussion, for which I'm most grateful. We heard an expose, a presentation of the picture of U.S. law on state immunity, on U.S. court practice in this field. We heard an expose on international law in this field. What I'm slightly missing so far, especially taking into account yesterday's statement of Mr. Ivanov during the plenary, is this breach between international law on state immunity and U.S. national law and law application on state immunity. Could the members of the panel be slightly more specific on what are the consequences of the fact that foreign state immunity is an issue of international law, public international law, to the application of U.S. law by U.S. courts? What is their opinion on the relationship between the U.S. law on foreign state immunity and international law? How, in their opinion, U.S. law corresponds in this field to international law? To what extent U.S. courts should apply public international law and not only U.S. law? Because this is not an issue of comity anymore. This is not solely issue of U.S. law. This is an issue of international law, as partially reflected in 2004 Convention, as reflected in the decision of the ICJ in Germany versus Italy, in the decisions of European Courts of Human Rights in this field. What could be, in your view, the remedies which could be employed by a foreign state which feels that obligations under international law with respect to itself were infringed by the decision of the U.S. court? And one more question. This issue was also mentioned. Separation of powers, prerogatives of the executive, the interference, so-called, of the executives with a statement of interest or amicus curiae or suggestion of immunity. I don't know how to call it in each particular case. But there is another aspect of separation of powers, because foreign state immunity issues an issue of international law and thus an issue of international, interstate, mostly, relations. Could it be that the court is infringing the prerogatives of the executive, pronouncing on the issue of foreign state immunity? Thank you.
Well, these are very interesting questions. What I suggest, we have next speaker right now, Ekaterina Kudelic. I think that her topic is very closely related to your questions. So what I would suggest, if we will hear Ms. Kudelic first, and then we'll have a discussion exactly addressing your questions, because exactly specifically the question of the interaction and who determines the law, whether international law in the context of the U.S. proceedings, and how the U.S. judge would defer or not defer to a statement or pronouncement of international law by international judicial tribunals or other international judicial or international authorities. That is a very interesting question, which of course relates to closely to our discussion today. With that, I'd like to ask Ms. Kudelic to move forward with her presentation, and I'm looking forward to a very interesting discussion. Thank you.
Yes, and let me make presentation in Russian, as I feel more fluent in speaking my native language. Вопрос иммунитетов, которые мы сегодня...
Question of immunity that we are discussing today. We have the topic that, as a matter of fact, we're talking about the U.S. Tribunal practices with state immunity being involved. And recently, just now, we have listened to a number of presentations describing to us how American lawmakers are concerned about it. Also, we listened to the UK presentation. Well, unfortunately, the Russian law cannot take pride in such kind of legislation. We only have 2 articles in the procedural codes based totally on different foundations, especially when it comes in the arbitration process. In the arbitration process, immunity is limited or functional, while the general jurisdiction courts are based on the absolute immunity principle, while the foreign state immunity questions for 10 years have been debated by the Russian parliament, the State Duma, and the promise for that particular act being passed is under question. And the 20-year war convention was signed by Russia, but it has yet to be ratified by the Russian parliament. You know, this approach appears to be rather strange to me when we talk about the general jurisdiction courts, about the foreign state immunity being passed as an absolute principle, while the immunity norm has never been based on the mutual principle, mutual acceptance principle. So it would be naive that foreign-based courts would honor the immunity of the Russian Federation while proceeding from the fact that we have the norm of absolute immunity held by other countries, other states. And we have seen that on a whole range of cases when they have not been communicating with foreign nations. And then arbitration practices involving foreign immunity dimensions, those practices are not very large. They are rather limited, I should say. And as a matter of fact, the arbitration court practices are very young here in Russia, only 2 decades, 20 years, but notwithstanding, of late we have seen an expansion of such kind of cases with foreign immunity issues being involved. So none of the cases has been elevated to the highest arbitration courts, but those cases have been heard effectively with the foreign nations' immunity being accepted, recognized. Well, there have been some cases when such kind of immunity was thrown out, was rejected, when recently there was a case related to the Czech Republic attracting a loan from the Russian bank, and as a result of a number of assignments and reassignments per loans, it was the Czech Ministry of Finance that started to hold that loan, and that's why eventually the matter was taken to court. And when the stakeholders started to challenge all of the arrangement, they started to refer to the fact that, after all, one of the related or interested parties, the Ministry of Finance of the Czech Republic, meaning that the state immunity is being incurred here. But the principal point I would like to highlight here, I'm not going to be theorizing here, I just want very briefly to say that, of course, the question of immunity, or as a matter of fact, Russia poses as sort of a recipient of those profound and expanded immunity-related principles and rules carried by American legislation. Yesterday's presentation by Ivanov is indicating that judges are very responsive to such kind of things, and nobody can be indifferent to such kind of things, especially when this kind of cases are reflective of foreign government involvement in that case. The questions of state immunity, well, they can be regarded as sort of a litmus test indicating how that or other state is perceived by another state. So, and we have seen such kind of cases with the executive branch of the U.S. government trying to weigh in that or other form on how hearings are conducted or have been conducted. So the role of the government, especially of the executive branch, might be direct or indirect, but also there have been some cases when some U.S. federal agencies, the Department of Justice, Department of State, have been providing some kind of statements of interest. And speaking about the specifics of foreign state immunity, I should say that Anglo-Saxon rule countries, the U.S. and the UK, the principal countries that command such kind of a profound body of legislation on foreign state immunity, they primarily are based from the principle that these are the rules of the national rule, domestic rules. So the question from Kolotkin really is legal. On the one hand, we have the UN international law determinations that have given a new lease on life on the foreign state immunity issues. And as a matter of fact, in some of the reference materials supporting the work of this roundtable says that the concept of foreign state immunity is obsolete. It is not at par with the current perception of democracy. And why is it the governments should have any immunity against some kind of legal actions? So this kind of perception really assumes that there should be some kind of a presumption. So for all kind of tribunals and courts, for example, if you take this or that matter to court, you cannot receive the desired legal protection, while another country that might be involved in that hearing would seek to do its best to assure the rights of that or other person against whom the action had been taken. There is another side to it, also very important, despite the fact that the questions of immunity have been recorded in the domestic national legislation. It is the international relations that really are important, especially when international players are involved in that or other case. So it happens that the national tribunals do not regulate some things, but they are regulating that on the part of unilateral perceptions rather than while proceeding from the internationally or generally accepted rules and procedures. So there are some inconsistencies that continues to be sustained here. So indicative here is, by the way, you need to understand that when we're talking about the immunity issues, there might be two different sets of situations. First, we have a situation when a tribunal decides whether that or other activity is covered by the immunity aspect when the activity involves not only states but also state-held corporations, companies, sovereign funds, central banks, and so on. And there is another situation when the state is sustaining some kind of investment relationships. And under these kind of situations, if you want to walk away from the immunity, that is going to be the payment for attracting the investment. You will never have any investment if you will not recognize this kind of rules. So that's the situation that shaped up on the action brought against the Schneerson Library. That's the case which is indicative of a U.S.-Russia relationship recently. It was one of the most unpleasant precedent of such kind of a situation being tackled. So within this case, what was made was the discussion of the legality of the rights by the plaintiff. On the other hand, the act of state doctrine had been denied on the grounds that the archives of things had been seized from the territory of Poland many decades ago. And secondly, we're talking about part of the library assets. We should also look at 1917. So some of the assets of the library of Schneerson had been seized under the Nationalization Act, and that Nationalization Act had been motivated by the adversarial perception of Judaism or Judea. So, as a matter of fact, that was the policy not only aimed at Schneerson, but at a much larger class of people, not necessarily people practicing that or other religion or that or other set of faiths. So, a set of very subtle questions emerged. So, there is one principle that needs to be held in mind. The question of immunity is the question of procedural law. So speaking about the Schneerson Library case, which was built on the expropriation acceptance issues, and the U.S. law also includes some grounds to deny foreign power or foreign nation immunity, that immunity could not be incurred provided international law principles had not been honored. And so this particular thing should be appropriately held in mind, and this predetermines that or other determination that might be passed by that or other court. So the questions of some cultural assets being seized, not the funds or money. With the money, all kind of things can be solved or decided much easier than when we're talking about the government expropriating some cultural products like books, because here we are talking about the part of the library that come from the 16th century, whether we have, whether we're talking about Hasids, part of the Jewish community that should be allowed to have access to those books. And you know, probably you don't know that part of that books had been transferred to the U.S. And then not all of the books had been repatriated. That's why the case had been heard. But this is not all tragic. I think in the arbitration court activities we have been very closely researching the American legal practices, especially when it comes appeals to the U.S. tribunals recognizing the immunities reaching to the activities sustained by different companies, different organizations. And the U.S. Practices are very large, especially when it comes to the presumption of innocence of an independent physical party, and especially when it comes to the property rights, title rights, and so on. These are the questions that we have been researching and studying, and to take them account. Lastly, I would like to say that the arbitration courts, you know, here in Russia, we take part in developing international law provisions. Recently, we have seen emerging a very important question about the International Bank and their rights and their obligations. And so the thing is not in whether to have immunity for central banks, but here we are primarily focused on finalizing how to regulate the activities sustained by central banks. As a matter of fact, this question has been debated for nearly 10 years, and speaking about the immunity of the national central banks. So this is still a debatable question, and whether to have the relevant arbitration court practices being sustained in keeping with that principle. So these are the major trends that have been ongoing, and these are the challenges that have been faced by the judicial system. Thank you so much, Ekaterina, for your remarks. Could you please close the door, because all right, thank you so much.
And I think that that sort of covers ends the first part of our discussion. And the second part, as you probably saw from the description of the program, and I'm sure Ekaterina, at least Ekaterina, I understand that she did read the description. That she noticed the one of the questions that was posed, and I have to admit that I thought that it would be a somewhat controversial question. I expected that, but there was no presumption per se was implied, and if it's read as presumptuous, I'll be happy to rephrase it. But I think that the idea is that simply, what is the current status? What is the current position of sovereign immunity? Is it getting diluted, or is it getting stronger? Where are we in the modern world? Where are we today? And I think that is the question that we're all discussing right now today. And we have interesting speakers, and we have, of course, very interesting question. And I'd like to invite, and I understand that Carolyn, you had wanted to make some comments.
Yeah,
so
in response to the
questions.
question from the audience, really, because I'm going to talk about arbitration where there is consent and you don't really have many immunity issues. But your question really could be the food for an entire day of debate, to be certain. But I think in a 1-minute overview, I wanted to mention that, of course, international law is very much a part of U.S. law and national law, to be sure. In most legal systems, international law is fully integrated, but the question comes in terms of the application of the international law. It conceptually eludes many, not good jurists like Judge Braden, but many of our jurists that are deciding cases, I think. And they do need quite often to be reminded, and state immunity is an area where I think it really infuses the international legal concepts are fully integrated in the national legal concepts, the same with active state and political question. And I think without a doubt there's continued justification for the immunity principles both in terms of a respect of sovereignty, but also you're protecting the public purse. It's at the heart of the democracy to protect the people's money. And it still has, I think, a relevance, but I wanted to mention two cases where the United States actually came into its own U.S. courts using a statement of interest in one and an amicus brief in another on the side of the Russian government and made a difference. In both instances, I think it was very important. One was about a decade ago. I was representing in a case where a private litigant sued the Ministry of Atomic Energy and AO Texnab Export Tenex in the U.S. courts. As a result, one of the commercial deals under the Warheads deal to sell return feed on commercial contracts, someone who was disappointed in not getting a contract tried to stop the deal from going forward. The U.S., in a flash, overnight came in at the district court level, which is extraordinary. It rarely happens. But at the district court level said, wait a minute, national security, this is clearly state act, sovereign immunity. The U.S. courts can't get into this. Get out of here. And the judge dismissed the case. Getting the U.S. to come in and do that is not an easy thing. And ultimately, the United States entered an executive order that said the trade of nuclear material, basically, under the Warheads deal between the United States and Russia is off limits to the U.S. courts, and that executive order stands today. It remains. And secondly, there was another, but I was representing the Saudis in this one, but the Russians were involved, and another firm was representing the Russians, and this just ended last October, where several class actions were filed suing over the alleged OPEC-related activities on antitrust issues vis-a-vis crude oil production and export. And in that case, the foreign interests ultimately prevailed on active state political question, as they should have. And in fact, I argued the active state political question issues, but the United States came in at the circuit level and said, wait a minute, the regulation within the sovereign territory of Saudi Arabia, of Russia, of whatever the producing states are, of their crude oil production and export, it's not for U.S. courts. This is clearly active state political question. And the circuit court certainly very heavily relied on the views of the United States there, and the Supreme Court ultimately affirmed. So just to let you know, there are those instances when, in fact, it makes a big difference, and not always in favor of the U.S. interests. Well, ultimately, I think they are the U.S. interests. It's just that the U.S. interests were congealed with the foreign state interests. So.
Thank you very much, Carolyn. I understand there are other comments from the panel on this issue.
Yeah, if we have time.
We actually do have time. I would say I'll leave 10 minutes maximum for this discussion at this point of time, because we have the second portion of our program, which is, I think, also very interesting, and there are very interesting issues that will be discussed dedicated to relating to the investment arbitration, where the immunity is waived, of course. But let's give it 10 minutes, and then we'll just see how it goes. All right, please go ahead. I'll let Glenn and then Sam. Would you please, Glenn?
It might be better if I go first, actually, because I'm going to in part respond to Carolyn and in part ask a question of Glenn.
Okay. Fair enough. Well, if you know what Glenn's question was, go ahead, please.
And not really respond to Carolyn.
That's fine.
First of all, many thanks for Dr. Kolodkin's question, which I think is exactly the right question. We're extremely lucky to have a former ILC rapporteur here in the room. Carolyn's answer, I think, goes some way to answering the question because it gives examples of where the US executive has acted to assert and defend the immunity of a given state. Now, that's all well and good, but I think what the question, in fact, brings to the fore is not just acts of the executive, but acts of the legislature, because what one sees as a matter of US law is legislation that, on its face, restricts state immunity. The very obvious example is the terrorist exception. And so the question really for the US lawyers on the panel is more, how do they envisage the US courts, or perhaps even the US more broadly, responding to really a weight of jurisprudence now that has led towards the International Court's decision in Germany and Italy? Because, of course, behind that, you have the well-known European Court of Human Rights decisions in Alazani and Kalabaropoulou, the well-known UK House of Lords decision in Jones and Saudi Arabia, decisions such as Bouzari and Iran and the Sheramelis case of the Human Rights Committee. So there is a weight of jurisprudence that is really sort of putting the pressure behind the question that Dr. Kolodkin has just asked. The international law side of it seems relatively clear because it comes to the international law answer. There is a right to state immunity. So I think the really interesting question is, well, how does the US respond to that?
Thank you very much, Sam. Glenn?
Well, I think we're talking about a very narrow category of cases here. I think, as Carolyn pointed out, in most instances, United States practice is going to be very consistent with what you'll see elsewhere. And it's worked very well, specifically with regard to the Russian Federation. What you have is a subset of cases that are causing, I think, most of the friction. And as Loretta pointed out, it's a relatively recent vintage, and it's cases involving basically looted art and antiquities, and primarily dating back a number of years. And I think, for reasons I'll explain in a minute, I think these cases, there'll be a bulge of these cases working their way through the system, and when they're done, effectively, what you'll be dealing with prospectively is what we'll be talking about this afternoon, which is investor-state arbitration, and many of these sorts of things will be resolved prospectively. So you're dealing with the expropriation exception under the Foreign Sovereign Immunities Act, very rarely applied until 2004, when this Austria versus Altman decision was rendered. A couple of important things from that case. The most important, which, as Loretta pointed out, is it held that the Foreign Sovereign Immunities Act was retroactively effective. And what that allowed was reopening all these old wounds from World War II, where, according to some statistics, up to 20% of all of the art in the world changed hands during World War II. And so you have very emotional issues dealing with cultural heritage, art, personal art. And Altman opened that up. And it's only been 8 years. And so you've got the case law evolving. We don't really know exactly where it's all going to settle. But it's this very small subset of cases involving old issues, often, Nazi issues. To some extent, if we deal with the Schneermann library, we're dealing with the Bolsheviks. You're dealing also, to some extent, with World War II, because there were really two sets of issues there with the library and the archives. The library with the Bolsheviks, the archive was World War II. And where this is all going to shake out I don't know. But I think we are dealing here with a very narrow set of disputes dealing with art. And a case law that has only been evolving now over a period of 8 years. And I think actually that the trend is to narrow it a little bit. I think you probably saw the high watermark of these cases with the Khalat decision and the Schneerman Library. And one of the unfortunate things about that case is that the Russian Federation originally was defending the case, but then 4 years in decided to drop out. So they're no longer defending themselves. And one of the questions that you posed was, well, how does a foreign sovereign defend itself in these instances? Well, one thing that you do is you show up in court, you have your lawyers argue the case, you defend yourself, you present your arguments, and instead of it being a one-sided thing. So the U.S. Department of Justice actually has made a statement of interest in the Schneerman matter, only on a very limited question relating to basically whether other property being on loan from Russian museums in the United States, whether they would be subject to execution to satisfy that judgment. And I think the intervention of the United States government with respect to that question was very positive and was favorable to the Russian government. So I guess I would say, again, we're dealing with a very narrow set of facts and a very narrow set of disputes that are very emotional, that are causing most of the friction. I would say that, is to echo what Carolyn has said, in the vast majority of cases, U.S. law is going to be very consistent with what you'll find in the UN Convention or the law of any other developed country.
Thank you very much, Glenn. Actually, Bart, and we will only, I understand that Mr. Plotkin would also like comment, but we have very little time on that, so I'll see if we can accommodate that, but Bart, go ahead, please.
All right, I'll try to be very brief. I'd like to take up the question and the tension that was highlighted by Sam Wordsworth between the recent ICJ decision in Germany and Italy and the Foreign Sovereign Immunities Act. And there I think one has to begin by recalling that the statute of the ICJ says that the court's judgments are binding only with respect to the parties to the case and only in respect of that case. You know, the United States obviously was not a party to the proceedings before the ICJ. Its views have not been heard on these issues, and I expect that the U.S. would want to be heard if this was ever to be enforced against it. That being said, I know that the State Department is looking at the implications of that case for the Foreign Sovereign Immunities Act. My own view is that customary international law cannot, under U.S. law, overrule a statute, and so it would require action by Congress in order for there to be a change. And it will be interesting to see whether there is legislation that is proposed either by the administration or by someone else to effect a change to the Foreign Sovereign Immunities Act.
What about the situation in Germany versus Italy case where there was a judgment against Germany in the Italian court? And Sam, maybe you can just give us a very brief comment on that. Can Russia ask the ICJ or some other international court to address this specific issue, to whether this specific situation would fall under any exception to the sovereign immunity? Екатерина understood it.
Россия пока, я хотела, вот этот вопрос был у нас.
We discussed this issue on the agenda regarding the structure between the states on immunities, and Russia goes along with the foreign countries in different areas. So just a year has passed, and on a bilateral basis they are trying to use the law on cultural heritage to agree the use of rules on immunity. I don't believe that this attempt would be quite promising, and all drafts prepared by US side and Russian side obviously indicates to that, because Russia needs absolute guarantees that all cultural values which are brought to the territory of the United States for exhibition purposes, they would be immune from any claims. And US side, naturally, and because of the legal system it has and other aspects, cannot provide this kind of guarantees and waive the sovereignty of the US courts. So they are trying, say they are seeking for the some kind of compromising solution. They are focusing on that, but maybe after that they will address the issue regarding the ICJ involvement. Hello. I try not to give these comments on the sovereign immunity, but I've been dealing quite a lot with these issues, and my company also works in the United States. I would like to stress one aspect which sometimes is ignored by the US legal community. The rules of application sometimes depend on with respect to whom they applied, and the rules of sovereign immunity sometimes is not used quite often. One example, maybe I have a biased position. We represented Venezuela in the US courts on bonds issued by Venezuela, and these bonds had indication that you can get money in any country of the world using these bonds. And the US court recognized in this case that it would be enough for the United States and for Venezuela to agree that these bonds could be used in the territory of the United States and to get some profits or to get some money on that. And indeed, we objected to that, and we hope that the Department of State of U.S. Department of State would support us, because it was quite a broad interpretation of the sovereign immunity and direct application of this rule. They did, but they decided otherwise, and they said that the Supreme Court should not make any ruling on this case and should not intervene in that. And they said that there is no interest of federal government involved here for the Supreme Court to make any decisions.
State to make any comments with respect to you, so it's hard really to address the specifics of your case, where you're representing the Venezuela, of course, but I'm really tempting to continue this discussion, but we're so short, we have so many interesting, so with my great apologies, if I can only have Sam Wordsworth to make very short comment, and then we will switch to the next topic. Thank you. Sam, go ahead.
Where there is the consent of the two states concerned. So, for example, on the case that has just been looked at very briefly, the Venezuela case, it would be for Venezuela, in a very theoretical case, to be able to establish jurisdiction in front of the ICJ, and if it could, then it would be trying to say, oh well, your courts are acting in a way that's inconsistent with international law. Germany, Italy is an exceptional case because there was a basis for jurisdiction in front of the International Court.
Sam, thank you very much for your comment. We will switch to our next topic, the international investment arbitration. And Bart Legum, partner from Salons in Paris, he will give us an overview of the investment arbitration regime and the implications and the ideas, the history of that. Bart, go ahead. Thank you.
Because otherwise I can't see the slides, and as you'll see, it's rather important for me to be able to do that. Can everybody hear me? Everybody can hear me. Good. All right, so first, how many of you in the audience have had practical experience with investment treaties? Okay, so we've got just a couple. That's good, because this is going to be an introduction to what investment treaties are, and so hopefully for those of you in the audience, this will give you the base that you need to understand the really interesting discussions that's going to follow from the other panelists. So, what are we going to do here? Can I make this work? There we go. Okay, so what I'm going to do in the very brief time that is available is first give an example to provide some context. I'm going to then give an overview of what investment treaties are, what they cover. All right, there we go. What protections they provide, and how those protections are enforced. All right, so first, here's the example. You have a transaction with two different acquirers, two different companies that are buying assets. They're both U.S. companies. There's Company A and Company B. Company A, in order to buy these assets, which are in India, forms a Delaware holding company and uses the Delaware holding company to buy those assets. Okay. Company B acquires those assets using its Dutch subsidiary. The terms of the two asset purchase agreements are otherwise identical. Then what happens is, 5 years later, India nationalizes the assets in question. It expropriates the assets and offers to pay half of book value as compensation. And as you probably know, half of book value is not generally a very significant amount of money. For Company A, the only recourse that is available, the only remedy that's available, is to bring a claim against India in Indian courts. For Company B, it has the possibility of going to international arbitration under international law against India. What is the difference between these two different scenarios? The difference is that there is no bilateral investment treaty between the United States and India, but there is a bilateral investment treaty in force between the Netherlands and India. And for those of you who are involved in transactional work, you know that a tremendous amount of time goes into tax planning and other aspects of how you structure an investment. When it comes to investing in some jurisdictions, the political risk can be as important a consideration as the tax considerations. And the difference to a client between having to go to courts in a country like India, where sometimes it will take 10 years or 12 years for a case to be heard, and being able to go to investment arbitration is a significant difference, one that adds value. Okay, so what are BITs? What are investment treaties? The first of these treaties date from the 1950s, but they became much more common beginning in the 1980s. So what's the concept? The concept was, and you have to put yourself back in the 1960s, 1950s, when the concept of the investment treaty was first devised. what was happening at that time was decolonization. So you were having all of these new countries that were coming into the world that were not developed. And the government officials of the world looked into their pockets and said, there's not enough money in the public treasury for us to pay for development of these countries. For them to be able to develop, they need to be able to attract private investment that will provide the funds they need to build factories, roads, everything that's required for development. But these countries had no established track record in treating foreign investment well. They had no established legislatures with a long history, and they had no established court system. So the question that was provided is, why would a foreign investor put money in such a country unless there's basic guarantees that their investment is going to be treated properly? And what BITS did was they provided kind of a modular, one-size-fits-all solution to this problem. And they did this by providing basic protections for investments that are set forth in the form of substantive provisions in the BITS, in the treaties. And they provide for international arbitration of disputes under those treaties as an alternative to the local courts that were not well established or sometimes viewed by investors as being corrupt. And there are over 2,800 of these treaties that are in force in the world today. So those are treaties in force, not treaties that are simply signed. What do they cover? The treaties cover investments that are made by an investor of one country in the territory of the host state, of the state that's welcoming the investment. Investment is usually broadly defined to include any kind of asset. No. And an investor of a country is usually defined to include a national, an individual that's a national of that country, and companies that are organized under the laws of that state. And it is not infrequent that indirectly controlled investments are also covered. So not just investments made directly by one company of a country in the territory of the other company, but ones that are made indirectly through other countries. Now, I should be clear at the outset that with 2,800 treaties entered into between thousands of combinations of different countries at different points in time, not all of the treaties are the same. And so there are significant differences in this body of treaties. What I'm describing here is just kind of the lowest common denominator, but of course every treaty has to be assessed on its own terms, and what I say may or may not be present in any given treaty. So what sort of protections do these provide? First, they provide typically national treatment, which is easy to understand. It means no discrimination in favor of national investors. It's an easy concept to understand. It's more complex in the application. Most favored nation treatment, which is really the same concept, but with foreign investors as opposed to national investors as the comparator. So no discrimination in favor of nationals, no discrimination in favor of foreign investors, with the one wrinkle that under international law, a most favored nation treatment clause can also make applicable a more favorable treaty provision that is in a treaty between the host state and a third state, although that has given rise to some controversy in practice. Here we go. No expropriation without compensation. The treaties routinely recognize that expropriation is legal as long as it is accompanied by compensation. Freedom to transfer returns and capital. Obviously, it does no good to have an investment in a country if you can't get the returns from that investment outside of the country, and these treaties protect that. Then fair and equitable treatment, which is a provision that is found in almost every one of these treaties and has given rise to considerable variation in its interpretation by various tribunals. Then full protection and security, which essentially means providing reasonable police protection for foreign investments. And the BITS typically provide many other protections as well. So what's the enforcement mechanism? As I said before, these treaties typically provide for arbitration of disputes about whether a state has lived up to its obligations. And that arbitration can be commenced directly by the company against the state. And this is a significant innovation for investment treaties. Usually international obligations can only be enforced by state-to-state actions, with some other exceptions as well. So the parties are the investor on one side and the state on the other. All right. The claim is that the state breached its obligations under the treaty, the obligations that were owed to the investor. And public international law, not local law, is the rule of decision. Of course, local law is always very important because that's what the measure is. That's typically what the device is that gives rise to the alleged breach. But it's international law that decides whether or not there has been a breach and not local law. And a successful claim results in an arbitration award that generally can be enforced just like any other commercial arbitration award against the state. And I know we're going to have some interesting comments later on today about that topic. So very briefly, what are the advantages and disadvantages from an investor's perspective to investment treaty arbitration? And this, I think, will help to define when you will likely see an investment treaty claim. First, from the investor's perspective, it provides a level playing field. Instead of bringing a claim against the state in its own courts, you can have that claim decided by a neutral, independent panel of international arbitrators. And there are a lot of different states in the world with different approaches to things, but there are some states where having the possibility of going to international arbitration as opposed to state courts is a very significant advantage. Second, it provides a procedure that is familiar to investors, which is often not the case for the litigation procedures in local courts of many countries around the world. And third, companies can be represented by law firms that they already know as opposed to relying exclusively on local counsel. The disadvantage is it's much more expensive than litigation in developing country courts. Typically, the cost of these cases is more on the order of litigation in the English or US courts than it is on the order of litigation in a developing country court. So there's transaction costs associated with investment arbitration. There's a negative impact on government relations. No government likes to be sued before an international tribunal and told that it violates international law. That's true of the United States government, I can say from my personal experience, and I also believe that it is true of most governments in the world. So it is not a positive thing in terms of the investor's relationship with the government. There is a reduced likelihood of settlement if you bring one of these cases. Why? Because when you start off your dispute with the government, you're dealing typically with just one ministry. You bring an investment treaty arbitration, and suddenly the Ministry of Justice, the Ministry of Foreign Affairs, the Ministry of Finance, and a number of ministries you've never heard of before are now involved in the case, and they see it as one in which they have a significant interest. More parties can often make it difficult to resolve a dispute. On the other hand, if you're getting nowhere with the one ministry that you were dealing with before, then sometimes stirring the pot can have a result. So what's the profile of these cases? A large amount in controversy so that it can justify the added expense as compared to developing country courts. Consensual resolution of the dispute is unlikely. And finally, that the negative impact on government relations is not important to the investor, whether because the government is not going to really care that much, as is the case for many developed states, or the investor's relations with the government have deteriorated to the point that it's no longer a concern. So that's my very brief introduction. Thank you very much.
Thank you very much, Bart. It was very informative. Dmitry will tell us about the call. Okay. Dmitry will tell you what he will tell you about.
It'll be a surprise. Keep you in suspense for about 5
Right.
seconds.
Pretty much.
Until you see the
Would you like to
If,
do the same?
Да, я прошу прощения за то, что я...
Извините, я буду говорить стоя, так... Well, there was a promise of a roundtable discussion, but we don't have a roundtable here, so I will be standing today. As a matter of fact, I'm going to be talking about the issue that is really pressing here in Russia and across the CIS territory. It's a question of liability of the state for actions of state corporations. But to kickstart my remarks, I would like to say that we need to make a few mentions of the applicability of the international law as the source for state liabilities. There is a large number of conventions dictating what states should do vis-à-vis other states or vis-à-vis private individuals. But speaking about the availability of a ratified convention, which would say that these are the rules that you should apply in order to treat another state appropriately. There are no such kind of prescriptions. And so what we need to do is to have a look at the customary international law. Well, as here, as a matter of fact, there is a draft of ILC articles on state responsibility. Well, if I'm going to mispronounce something, Mr. Kolotkin will remedy my observations. Well, speaking about those rules I'm going to be talking about, they have yet to be ratified, and they are still in the form of a draft since 2001, notwithstanding most of them, and especially if you look at the decisions by past investor state tribunals, they are reflective of the international customs that are nearly or close to being binding precedents. So in my presentation, I will be referring to those rules and provisions about the state liability, and will be telling you about to what extent the tribunal practices really are reflective or non-reflective of the demands carried by the articles of this document. Also, I will pass a few comments. I will make a few comments available in the Russian language and in the English language as well, hopefully in other languages too. So now and again I will be also citing from some other documents. Well, speaking about the principles of attribution of liability of state, so look at Article 4, which is about a structural test. You know, there are three forms of liability. Article 4 is, I have already indicated, it's about structural testing, Article 5 about functional testing, and Article 8 about control testing or monitoring or validation testing. Interestingly, under Article 5 and 8, but not Article 4, you are required to establish a linkage between the relevant parties. and the action that needs to be attributed to the state. So, in generally, as the document reads, the conduct of any state body shall be considered an act of the state under international law, whether the body exercises legislative, executive, judicial, or any other functions, whatever position it holds in the organization of the state, and whatever its character is a body of the central government or of its territorial unit of the state. That body includes any person or entity which has is acting in that capacity in the particular instant. Article 4, as a matter of fact, empowers the relevant party, whether it is part of the government or not part of the government. Well, speaking about the notion of body, it is any entity which is holding that status. So the principle of international law, as a matter of fact, is always rooted in the domestic law. This is just one of the cases where the internal law or domestic law matters. The disputes that are settled in keeping with the domestic law, they might be resolved through incurring some elements of the international law as necessary. And there is another principle here that needs to be involved, and which is the government cannot use its domestic law as a foundation, so to say, to avoid liability from its international commitments. Well, Article 5, this is about functional testing. The conduct of a person, a group of persons, shall be considered an act of a state under international law, if that person or group of persons is in fact acting on the instructions, this is very important, on the instructions of or under the direction or control of that state in carrying out the conduct. Well, Article 8, this is about monitoring or validation. This is about not necessarily a company or a physical person. This is about any entity or a group of physical persons. This is about the conduct of a person or a group of persons, and that conduct shall be considered an act of a state under international law if the person or group of persons is in fact acting on the instructions, as I have already indicated. The commentary to the ILC's articles explains that where the state was using its ownership interest in or control of a corporation, it specifically would be in order when it comes to its being applicable. Let's look at some practical cases. There have been a number of practices. Some of them had been covered nearly 11 years ago in 2001, and I believe as a result of disparities in interpretation of the norms of international law, apparently there was a different test was used. If you look at the Maffezini versus Spain, this case, Maffezini versus Spain, applies two tests: the structural test of state creation and capital ownership, and the functional test of performing activities of a public nature to determine whether prima facie the acts of the entity at issue could be attributable to the respondent. This attribute, the state and public interest is supposed to be looked at so that the relevant linkage should be established, especially when we're talking about some kind of an action being challenged. So the presence of this state in that or other litigation needs to be explicitly determined before passing that or other judgment. Then there have been some other cases when some Articles 4, 5, and 7 have been applied, and those are more modern cases. As a matter of fact, I break them up in two generations. There have been some judgments at the start of the century, Salini versus Morocco, say, Vienna Hotels versus Egypt 2000, Maffezini versus Spain 2001, Salini versus Morocco 2001, and there is another generation, new approach, analysis following the draft. So there are two categories: old approach, which is truncated structural and functional analysis only, and the new approach, a more profound analysis following the draft of ILC articles. With Maffezini versus Spain, well, in that particular case, there was a measure of research and analysis, but that particular analysis had not been complete. In order to really arrive at the fully balanced decision. We are not talking about large companies like Gazprom, but the principal function was to develop to make a contribution to the development of a province in Spain. In the Maffezini versus Spain. So as a matter of fact, the problem there was to check and see whether some government interest was present, though of course the commercial interest was there, but what was the size of that interest? And there is a series of new approach-based cases where I have already indicated analysis or research is much more profound. So these are the cases starting from 2008 through today. These are Yen de Nul versus Egypt, EDF versus Romania, and Damta versus Ukraine, 2009. Maybe my colleagues would not embrace my perception, but in principle I believe that now we have a totally different ongoing trend, which is to be more strict in observing the application of these articles. Now, speaking about the application of those rules to state corporations, Salini versus Morocco examines the extent of state ownership of a corporation, holding that due to its extensive shareholding as well as ministerial representation on its board and offices, the entity was controlled and managed by the respondent state. Well, as a matter of fact, if you applied that particular state, it really would be very difficult to arrive at a conclusion that the efforts sustained by that or other company could not be fully analyzed by an unbiased court. In the Nikon versus Latvia award finds that that the state was responsible for the failure of a state electricity company to pay electricity tariffs to investment. Why is it that the state is held liable here? Well, because the state was aware of the company not coming up with the payment. But as a matter of fact, action or inaction, as a matter of fact, they make no difference, because you can take you can initiate an action against some party for action or inaction. It is all about the nature and substance of that or other action and inaction. Anyway, we are not talking about the automatic shifting of liability from an entity to the government. So here we are talking about whether the government or the state really allowed for some kind of an inaction and breach of the applicable international law. It is only then the determination of the court and judgment was be fully balanced and substantiated. But sometimes it is a challenge to do this. And to wrap up my remarks, I will skip some slides, and to conclude, I will only say that, you know, there are other ways that we should look at when the state poses as sort of a guarantor for that or other move or activity. And then, as Bart indicated, there are some principles under which the government could be sued for breach of some direct rules, like justified expectations that come to be undelivered. So then, well, as a matter of fact, there are different kind of situations. But, you know, speaking about investors, of course, they proceed in keeping with the achievable strategies in order to really build up the right evidence, a body of evidence to prove that the government is to blame. Then there are so-called umbrella clauses that we need to bear in mind. Well, but here primarily we need to be very specific about the thrust of that clause. And as a matter of fact, those clauses might generate some fresh liabilities, especially when we're talking about contractual obligations or commitments. So I'm done with my remarks. I turn over the floor to Jim. Thank you so much. Dmitry.
Interesting. Well, we have heard a lot, of course, everyone heard about the fraud and corruption, especially in the context of domestic legal proceedings, where investors or foreign companies, they allege, they bring claims that the system was corrupted, which prevented them to proceed with the contract, where there are competitors or acted improperly in bad faith. But what about the investor's conduct himself? What if the investor's himself or herself or itself is involved in illegal behavior, and that investor brings an arbitration claim under the investment treaty? Can the government raise that conduct of that investor's conduct as a defense to the claim? And that's, I think, what Carolyn is going to talk about, right?
That's right. I have, I hope, slides. Great. Thanks to the brilliance of Glenn, who was able to get my slides onto the computer. I wanted to start today with just a very quick overview of the, whoops, let's see if they change. Oh dear, we only got one slide on. Let's see. There, oh, you point this way? Okay. All right. I'm going to start with a quick overview, I think, of the more than 60 Russian bilateral investment treaties that Russia has entered into since 1989, if I can get this slide up. And in looking at these, you'll see that there are 23 with EU countries, 22 with Asian countries. The U.S. indeed has negotiated and signed but never ratified a bit, and in fact, Russia has terminated its provisional application under the Energy Charter Treaty in 2009, and given the trade flows in the Russian business, that's an important treaty to be sure for the Russian Federation. I think the interesting thing, you heard, of course, from Bart about the general overview of the kinds of proceedings you can bring, but in the Russian treaties, the bilateral investment treaties, not all of them contain a consent to exit arbitration. The Japanese treaty does, and there are a few others that do. There are consents to other types of arbitration. So one of the things you need to pay attention to, and I think we're going to hear more from Sam about selecting jurisdictions you need to pay attention to, is what the nature of the sovereign's consent is in the bilateral investment treaty that ultimately your client is investing under in order to ensure that you have the kind of arbitral coverage or consent that you really want to have. And certainly this slide looks at the trade flows both into and out of Russia in the past since '95. And it's been extraordinary in terms of growth and development both ways, outbound and inbound. Of course, there was a peak in investment flows in 2008, as in most countries, but it really is picking up again, which means for each of these investments coming in or going out, we have lawyers that are involved counseling on the transactions and lawyers that are involved, of course, in any of the disputes that arise. So it's the bilateral investment treaty area. You don't have to be tangled up in U.S. courts or Russian courts. You don't have to be dealing with concepts of sovereign immunity. There's already a consent to arbitrate or you wouldn't be there. And if you don't have one under a bilateral investment treaty, at the time of the investment, of course, you can include a consent to arbitration, including exit arbitration in your contract. And some of the oldest exit cases, like Amco Asia, are contractual clauses or under the foreign investment decrees. So it's something that we as lawyers must pay attention to at the outset of a transaction to ensure that the parties are protected. You know, the interesting thing, though, in looking at the arbitrations that Russian investors and the Russian state have been involved in, they are about equally divided. Russia, as a host state, has 9 different arbitrations under bilateral investment treaties, and we see that at least 9 Russian investors investing abroad have asserted claims under using the benefits of the existing bilateral investment treaties. So it's really a very balanced benefit for both sides. Those coming in have additional security in terms of the level of protection of their rights they can expect at an international level by the Russian state, or else it will be required to respond, as we've heard in depth about the international law protections from our 2 prior speakers. The other interesting thing is kind of the evolution of where the investments are coming from and where they've been focused. And in the earlier days, of course, the old USSR states were those where you were most likely to see the trade flows, but things have really changed and gone well beyond that in today's investment flows. In terms of the treaty disputes, I've just made a catalog of the types of disputes that we've observed. And you can see that there is a lot arising out of oil and gas, but of course there are also telecommunications, etc. So these are treaty disputes by Russian investors under Russia's treaties overseas. And these are the disputes. This slide gives you some idea of the kind of disputes that the Russian state itself has been involved in arbitrating. A number of them, of course, arise out of the various Yukos transactions and oil and gas transactions, but there are others. And it's just interesting to note in the finance area as well as in other areas that there have been a number of arbitrations. And of course, it's difficult to talk about trade flows and investment without focusing a bit on the consequence of fraud and corruption. And this isn't unique to the Russian situation. We find this in most host states in developing economies. And the question is, what consequence if an investor is involved in both fraud, corruption, or violations of host state law? And there is really an evolving or emerging jurisprudence over the past decade or so in this regard. Certainly under the bilateral investment treaties themselves, you saw that you must have an investor with an investment. Well, the other portion of Article 1 of that clause is that the investment must be made in accord with host state law. And you see that. I've quoted one of the, let's go back. No, oh dear. I hate to lose it. I've quoted one of the treaties in the definition of what is an investment, and you'll see in accordance with the laws and regulations of the host state, there are marginally different formulations in other treaties, but the consequence is about the same. There are treaties without the in accord with law clause, and there are contracts that do not have an in accord with law clause, but are governed substantively by host state law. And I'll talk about the sets of cases under each, but you'll see where the decisions have been going is that even in the absence of an in accord with law clause, their fraud and corruption and violations of law can be the basis for the inadmissibility of the claim. So the consequence of fraud and corruption when you've got an in accord with law clause or a violation of law is jurisdictional. Generally speaking, the arbitrators have rejected jurisdiction under Article 1. And even when there is not the in accord with law clause under the treaty, and I'll go into one or two of the cases, or under the contract, the arbitral tribunals have rejected on an admissibility theory the claims, saying that they are unenforceable as a matter of host state law, international public policy, international law, and good faith concepts that exist in most national legal systems. So we see that the fraud and corruption in the making of the investment deprives the tribunal of jurisdiction, and this is accepted in most cases. The difficult part generally is the proof of the fraud and corruption or violation of law. People don't often admit to it, so you need either good witness testimony or good contemporaneous documents in proving it if you're defending the state, or in, of course, defending it if you're representing the investor. It can also be not only a jurisdictional defense, but depending on the language of the treaty, it can be a defense on the merits. In some of the actual merits provisions, there is an in accord with law clause under fair and equitable treatment provisions or other of the more substantive merits type provisions. Two of the cases that we've seen with in accord with law clauses where there has been a rejection of jurisdiction is the in case of the El Salvador, and in that case the investor obtained the treaty on the basis of bidding where it presented actually false information about its financial ability, about its ability, its experience, its capacity, who its partner was going to be, their experience and capacities. So fundamentally, the state approved the investment and accepted the investment on the basis of fraudulent representations. In the face of that kind of illegality, the tribunal concluded, as it should have, that clearly this is illegal. It's not included within the state's scope of consent when it consented to arbitrate and respect claims under the terms of the bilateral investment treaty. In Fraport v. Philippines, it's another dimension of that. The original award, the tribunal in fact declined or rejected jurisdiction under Article 1 of the treaty because there was a knowing and intentional violation of the host state law for, in fact, exceeding the nationality requirements that were in the Constitution and the laws, but hiding that they were doing it, so it violated the anti-dummy laws. It was later annulled on a procedural issue, and it's back for retrial. The other set in investment contracts, you see generally if there is a violation of law or fraud and corruption, dismissals on the basis of inadmissibility. In the Piatco v. Philippines case, it arises out of the same transaction, basically a concession contract to build the international airline terminal in Manila. Same activity, because this was the local partner bringing a contract case instead of Fraport, the German partner, bringing a bit case. The local partner, again, lost in an ICC arbitration, Philippine law applicable, Singapore lex arbitri, but the same thing, breach of the anti-dummy law that had been covered up and misrepresented, and in fact the claims were all rejected as inadmissible, and the Singapore court when challenged in fact affirmed. The World Duty Free v. Kenya is another case. There was actually testimony of the president of the country saying he took a $2 million bribe at the time of letting the contract, and the extraordinary case. And there wasn't an in accord with law clause, but nonetheless the tribunal found that this was clearly a violation of transnational public policy against bribery and national law. This is one where we see the national law and international law being very consistent, and the tribunal rejected it as inadmissible. Another case where we had a treaty without an in accord with law clause, it was the Energy Charter Treaty, which does not have an in accord with law clause. And in that case, again, the investor misrepresented to the state who the investor was and the experience and financial ability and everything else about it. And while there was not an in accord with law clause, nonetheless, the tribunal determined the behavior was contrary to Bulgarian law, it was contrary to international law, it was contrary to international public policy, good faith, fair dealing, and it was rejected as inadmissible. They didn't do it on jurisdiction, however. They did it on inadmissibility, and they made us try the whole case. Which is, but there are severe consequences, in fact, to the violation of law and fraud and corruption. So in assessing an investment situation, it is always a very important issue to go over with your investor, or when you're representing a state, to go over in terms of what the evidence is that you can develop in the defense. They're important emerging issues, and I think important for all of us as lawyers to pay careful attention to. That's it.
Thank you. Thank you very much, Carolyn. Indeed, I'm sure there are a lot of questions regarding that issue. It's just unfortunately, there's very little time. I just wondering if that president of Kenya, he saved more Kenyan money by making this admission, finally got himself some immunity against the prosecution for bribery by making this testimony. But it is indeed fascinating, absolutely fascinating. Both Bart and Carolyn mentioned about the importance of planning in international transaction, in the investment transaction, where you want to use the treaty country. But how far can you go with this? How can, for example, a Russian citizen use a treaty country to invest capital back to Russia and then claim protection under that country's treaty? Can a foreign citizen who invested in Russia through a vehicle formed in a non-treaty country then sold the company, then transferred the investment to a treaty country while anticipating the dispute? How far this planning can go, and what law applies to the investment treaty arbitration? These are the questions that I'm hoping Sam would reflect upon. Go ahead, Sam. Thank you.
Thanks very much. I will reflect, but I'm going to reflect relatively briefly, as I think we've arrived at the time of the session where less is rather more. It's absolutely critical to focus into the question of consent. What have states consented to in signing up to these bilateral investment treaties? Because all the cases that Bart has touched on in his very helpful introduction, and the other cases that have been referred to, show that bilateral investment treaties really have teeth. They end up in awards enforceable against states in the amount of hundreds of millions of dollars. So it's very critical indeed to focus in onto the question, what have states consented to? I'm just going to pick up on two of the issues that go to consent. And the first of these is, what has the state consented to in the terms of who can sue, who can bring an action under the bilateral investment treaty? The issue that Jean has just alluded to here is what happens if, to all intents and purposes, I am a Russian shareholder, but I've incorporated a company in another state which has a BIT with Russia. Let's take the UK-Russia BIT as an example. So let's say under the Articles of Association, the Russian nationals hold 99% of the shares. The Russian nationals direct the company, but they nonetheless wish to bring a claim under the BIT against Russia. Can they do that? Now, the answer, of course, in any given case is going to depend on the wording of the treaty. And as Bart has pointed out, the treaties are different. You have to look very carefully at the individual of each wording. And the question of who qualifies as an investor will depend very typically on the question of where are you incorporated, if it's a company, or where are you a national if you're an individual. But there may be broader concepts, for example, concept of control, so far as concerns companies. On the example I've just given, the UK company, which is to all intents and purposes Russian, there is an answer given in a case called Tokios, Tokelis and Ukraine, a very well-known case, where the company, in fact, was a Lithuanian company, but was 99% owned by Ukrainians, managed by Ukrainians. Was that sufficient to qualify under the Lithuanian-Ukraine BIT? In fact, yes, because The relevant criterion was one of where is the company incorporated. Sounds like a harsh decision, and it's a very important and to some persuasive dissent by the chair of the tribunal, which of course is wholly exceptional for the chair to dissent. That's Prosper Weil, of course a highly distinguished public international lawyer, who took the view that the protections, the arbitral protection put in place by the 1965 ICSID Convention, this being an ICSID arbitration, is for international disputes, not disputes which he saw essentially as being a national dispute, a Ukrainian domestic dispute, which had perhaps fortuitously been allowed to come within the relevant BIT. But Tokelos pretty much holds the ground despite that dissent. So one is looking at a situation where there will be a strict application of investor requirements in the BIT. And you're not looking at questions such as effective nationality, which comes in through which might come in through the very well-known ICJ Notterbohm case. What happens then if you are thinking, I see the bilateral investment treaty, I see that my nice factory has just been expropriated, therefore I want to change the nationality of my company so that I come within the scope of a bilateral investment treaty, because unfortunately for one reason or another my company doesn't have the right nationality for the BIT. Can you do that? The answer to that, I think, reasonably unsurprisingly, is no. You have to do your investment treaty planning in advance, just like tax planning. If you do it in advance, then it will be upheld by the tribunal. There are various cases to show that, no matter if the fact that you have, just as you planned for tax purposes, you have arranged your corporate structure by reference to the BIT. That is permissible so far as concerns BIT tribunals. What is not permissible and what is considered to be an abuse of right is to restructure your investment to try and get BIT protection once the dispute has commenced. And there are a couple of strong cases on that, one called Mobil and Venezuela, the other Phoenix and Czech Republic. Those cases are important in establishing the basic rule so far as concerns pre-existing dispute. Of course, one must always be cautious about talking about rules. These are only cases. They're not, strictly speaking, precedents, but the reasoning in both is relatively persuasive. There are now a couple of important cases either just starting or in the course of decision, or one which there'll very shortly be a decision on, where there is a grey area, and these cases need to be followed carefully. I'm thinking, for example, of the case of Pakrim and El Salvador. And the grey area is that the investor has had some form of an existing dispute. It's then, but without any BIT protection, there is then a corporate restructuring so that the company which is disputing with the state is held by a company which qualifies under a BIT. There is then a further act of the relevant stage, which is said to found a new dispute. Can the investor then rely on the BIT in that case, or is that abusive corporate planning? The answer to that, one hopes we will see some helpful clarification in these cases. Particularly, one needs to keep an eye out for the Pakrim and El Salvador case, where the award should be out in a few months. Pending that clarification, the obvious message for investors, of course, is to do your BIT planning long before the first whiff of any dispute, long before any expropriatory activity of the government may be foreseen. The second issue of consent that I want to touch on very briefly now is the issue of consent to applicable law. Now, 5-10 years ago, people in the investment treaty world were very concerned about the investment treaty tribunal's ability to apply the law of a given contract and to assert jurisdiction over breaches of contract, pure breaches of contract, which weren't breaches of treaty. That issue has been resolved to some extent, and certainly has been talked enough to too great an extent. The issue that is now coming to the fore is the one of applying treaty sources outside the relevant bilateral investment treaty. So, to give two current examples, in one particular treaty case, Rosales and Romania, the investor has said, not only did you breach my BIT, but you breached the European Convention of Human Rights. In another example, White Industries and India, the investor says, you breached my bilateral investment treaty, and you did that through failure to enforce an arbitral award, which you are internationally obliged to enforce in accordance with the New York Convention. And so the question there is, what is the scope of the tribunal's jurisdiction? Can it apply international law from these exterior sources? Now, it's important to emphasize that this is a different question to the question of interpretation. States, investors perhaps to a lesser degree, but certainly states, are more and more looking to other treaty sources to help interpret provisions like the fair and equitable treaty provision. Very frequently now, one is seeing reference to human rights treaties and states putting forward their human rights obligations as a means of informing what is fair and equitable, so far as concerns application of the fair and equitable treaty standard. Now that should be put forward as a matter of interpretation. If the state starts to go beyond interpretation, there may well be a difficulty of applicable law. As a matter of interpretation, it's permissible. Under Article 31(3)(c) of the Vienna Convention, a tribunal may and indeed shall take account of other applicable rules of law applicable in the relations between the parties. So that is much less problematic. The question of applying exterior treaty sources is problematic. For example, to take the ECHR example, if the Rosales and Romania Tribunal had gone on to apply the European Convention of Human Rights, what then does it do with the strict admissibility requirements in the ECHR? What effect, if any, does it give to the rulings of the European Court of Human Rights that it alone decides jurisdictional issues concerning the ECHR? What effect, if any, does it give to the exclusive dispute settlement provision in the ECHR? So suddenly one sees an awful lot of external problems coming in front of the BIT tribunal if it wishes to enlarge its jurisdiction. So far as concerns the New York Convention, in a sense it's simpler because there is no exclusive dispute settlement provision. But if we look at the recent decision in White Industries and India, there the tribunal is very cautious indeed about saying that it can apply the convention. In fact, it doesn't say that. It doesn't even suggest it. It notes the argument that breach of the convention would amount to breach of the BIT, but expressly doesn't decide it. One of the arbitrators has a lengthy footnote on the point, but that's all there is. And when it comes to deciding on the issue of did the investor have legitimate expectations by reference to the New York Convention, this essentially gets a side swat away, and it's just decided on the on the matter of basic principles, the question being put forward by the tribunal is, how could you legitimately expect what you say is compliance with the New York Convention when you know how Indian courts tend to approach these precise issues of application of the New York Convention? You're an investor, you've gone in with open eyes, and you get essentially what you bargained for. And so White Industries and India doesn't decide at all by reference to the New York Convention. Is that the right approach? In a couple of minutes or so left to me, I want to suggest a couple of pointers that suggest that that is the correct approach. The pointers are, first of all, as ever, it's always helpful to look at the public international law, state-to-state jurisprudence on this point. And there are a couple of helpful cases that date back to about 10 years ago between Ireland and the United Kingdom, which concern a nuclear facility built by a United Kingdom operator, which was said to be polluting Ireland. There, Ireland relied on a whole host of exterior international sources. It brought the claims by reference to treaties A and B, but in bringing those claims, it relied on treaties C, D, E, and F, as well as A and B. Both tribunals, in effect, said that that was not permissible. And one of the reasons I think this is an important reference point is the arbitrators in those tribunals are very familiar names in the investment treaty context. But the cases are the OSPAR case and the Mox Plant case. And I'll just read you the two lines of what the OSPAR case, their conclusion, was that if they were to allow this extension of jurisdiction, if they were to apply or to interpret their broad applicable law provision as permitting this, then the effect would be to turn the relevant treaty into an unqualified and comprehensive jurisdictional regime in which there would be no limit, ratione materiae, of the tribunal, to the jurisdiction of the tribunal. And that, of course, is very much the question in the current BIT context. Is there any limit on the jurisdiction, ratione materiae, of the jurisdiction of the tribunal? The Mox Plant order of 24th June 2003 appears to take a similarly restrictive approach, including, not least, in staying its proceedings and allowing the matter to go forward in front of the European Court of Justice. The other point to bear in mind, and this will be my concluding point, is to look at Article 31.3b of the Vienna Convention of the Law of Treaties, which deals with the issue of state practice. Because, of course, state practice may well be very relevant indeed in terms of, for example, where have states taken their disputes concerning the New York Convention? Of course, they've taken them to the domestic courts. Disputes concerning the European Convention of Human Rights, of course, they've taken them to the Strasbourg Court. So that, sorry, when I say states, I mean nationals of a given state as opposed to the state itself. To conclude, there is a difficulty here, and the difficulty concerns the proliferation of organs. And I quote here, it's important to negotiate the proliferation of organs with tremendous difficulties for the definition of their respective jurisdiction. And that's not a quote from the well-thumbed-through ILC 2006 report on fragmentation. That's a comment made by the UK delegate in June 1950 when they were negotiating the European Convention of Human Rights. So far as concerns the proliferation of BIT tribunals, which I'm sure is welcome to all on this panel, perhaps not all in this room necessarily, the task of the BIT tribunal will be to interpret and apply the BIT as part of the semi-coherent system of international law in which we all live. Thanks very much.
Thank you very much, Sam. And we had some ideas, we had some thoughts for Ekaterina to say a few words about the Russian position with certain international treaties and convention. But we are unfortunately, and maybe fortunately, from a side, we're very close to lunch, and I really don't want you to want to hold you anymore. I would like just to mention a few words in conclusion. First of all, of course, I'm grateful to all of the speakers. My view, and I hope that you will join, you will also agree with me that they did an exceptional job in reflecting on the very interesting topics, very current topics, the topics that are very hot, and they're right there that we need to deal with in our current international legal system. There are, of course, as a summary, there are two general ideas. There is an international law in the understanding of international bodies, in the understanding of the public international lawyers, and there is also international law in the understanding of the local judges and in the understanding of the local authorities. How do you square these two understandings? How do you, because there are disputes. There are disputes regarding that which lead to misunderstanding. And how do you deal with this? How do you deal with these issues? And I just let you think about that. Let you maybe perhaps if after this panel you will have a conversation with the speakers, and I'm sure that they would be able to answer your questions. I'm hoping that they would be. Maybe there are some ideas that will become that will be further developed in order to close the positions of different parties, different points of view. And of course, the investment arbitration, this very important device, very important modern device for resolution of the commercial disputes, of the business disputes between the investors and the states. Of course, it did address one issue, where to sue and how to deal, and whether there is a consent, whether there is a waiver of the immunity. By the way, not altogether, not completely, because there are issues with enforcement of certain arbitration awards, as Ekaterina was planning to talk about. Unfortunately, we don't have time for that, but that has also brought numerous other issues and very interesting issues that we've heard about today, and this emphasized the importance for transactional lawyers, and not only lawyers, but also for the governmental authorities to plan ahead, to understand what the implications are of certain transactions, and to understand what the principles of foreign legal systems are which may apply to a certain specific transaction. With that, I'd like to thank you. I'd like to thank you, our audience, for being patient with us, for your very interesting questions, and I'd like to end here. Thank you very much, everyone.